Yeah, that directive that they were refusing. But let me give the embassy a shout now.
Yes, asseblief.
Jim, you must also give mayor a shout here at Aliwal North. You don't take the issue of Aliwal North serious. They don't have water. We don't have water here.
No. We're taking it serious. Angisho kufuneka sibafonele phela mhlala.
Bafonele ngiyazi ukuthi mabafonele kuwe mhlambe bazogijima. Bafonele balungise land as soon as possible.
Iland of amanzi.
Akunamanzi wena ngoba uyasikhipha masikhuluma iqiniso usikhiphela into engekho. Isikhathi sakho la. Wena ngoba you are not the chairperson of the portfolio committee.
Uzile mhlala.
Unenhlanhla ngoba
ulile mhlala. Usenso.
Hayi. Ufika late isikhathi bani manje?
Ufika late khala kilumo unwile.
Unwile ma?
Unwile.
their plans again, because I don't know what happened, why the buses have been changed to leave the parliamentary village at 8:30. So I don't know that arrangement, and I've just seen it in the message in the morning. I want to apologize, members, that you have to wait. So I'm going to ask that we start with our meeting, and I'll then ask members to observe a moment of silence for meditation and prayer.
Chairperson, before we move on with the meeting.
Okay, I'm listening, Honorable Member.
Yeah, no, Chair, we hear you. It is not your problem. It was the problem of Parliament changing times. But the chairperson, we have rules that are guiding us. So rules are specifically for these situations like this ones. We can't wait for you for close to 30 minutes waiting for you because there's a problem of transport arrangement.
Honorable Masala.
Whereas we have rules. The rule says there's any problem.
No.
Order, Mshala. The meeting is not yet open. Mshala is out of order.
No. Honorable Masala, please allow me. I've informed the secretariat as early as I think it was even before 8:30 that you must indicate that there is a message that the buses will leave at 8:30. I therefore request that we start at 9:30.
Wait for me to finish speaking. But the way you are speaking, is speak like Yunkosi, like kule portfolio committee.
No. Honorable Masala,
Allow me to
please
speak,
don't.
and then you come after me, you emphasize.
No, Honorable Masala.
Honorable Masala out of order, Chair.
Every now and then when I speak,
the meeting is not yet open.
With our meeting, and then we can then allow our visitors to leave, and we then start this process that we want to engage, because we have invited people who are not part of us in this meeting. Can we do that?
No, Honorable Chair, may I please address you just on one thing that you have just raised. Chairperson? Honorable Chair?
Because chairperson akukhathalele.
No, I wanted her to give me an opportunity.
I'm honorable, honorable. Are we busy? Not ho.
So correct, Shabna.
umsebenzi wakho loyo wena ucorrecta into ezingekho le ufanele uzicorrecta uzicorrect
members, and thank you very much to our guests. I'm now going to allow the Secretariat to note the apologies. Vuyokazi.
Madam Yogas, we did raise with you. You are not talking to us. Please talk to us, Madam Yogas.
Good morning, members. Honorable Powell will not attend the meeting today. She will be traveling. That's the only apology that I have for today.
Honorable Chair. Chairperson.
Vuyokazi. Yes, I'm there. Vuyokazi, your line is very bad.
Yes, Chairperson, I'm listening.
The chairperson driving.
I said, Honorable Powell won't be attending today. She is traveling.
Yes, I was saying that your line is very bad. Okay.
Yes.
Okay, then the apologies are being noted.
Chairperson.
GM.
Mina ngicela ukuthi excuse ngo-10 to 11 ngiyo-attend the economic class that then I will join again if ngisasekhona.
Okay, GM is noted. Let me take this opportunity. Who's that?
Chairperson.
Okay. Honorable Ngwezi.
Siyabonga sihlalo. Ngibingelele ku-Deputy Minister namalungu onke portfolio committee. Ngicabanga ukuthi sihlalo ngoba isikhathi sama-apologies lesi. Leya apology oyisho umhlangano ungakawuvuli. Bekuyisikhathi sokuthi uyisho manje. That apology you actually gave before the meeting, it's much more relevant now that we are dealing with apologies. For you to apologize in this portfolio committee for the meeting starting at this time, because there are rules that governs the sitting of portfolio committees. And to check whether, Chair, in line with the rules, is this meeting still in line with the rules? Thank you, Chair.
Thank you very much, Honorable Ngwezi. As I've indicated, the meeting is still under the rules, primarily because it's not the doing of the chair. It was the issue of transport, which will raise it with Parliament, that it has inconvenienced the committee. I will write the report to the Speaker about the changes of the transport, but I again say to members, I apologize because I couldn't just say, let's start with the meeting without saying, let me apologize that we have to delay the meeting for 30 minutes. And unfortunately, I don't know what happened because I've requested the Secretariat and I've explained to her in the morning after I saw the message on the WhatsApp on the traveling arrangement. Honorable members, we were called to Parliament, all of us. If you were in Parliament, you're going to have the similar situation with me. So I'm not saying you should accept my apology. You have the right to reject it because you were given permission to stay at home and we were recalled to Parliament. So I want to profusely apologize for starting late and allow us to start with our meeting, and then we can then, after the guest has left us, we can then interact and even look at the time. If the time for other meetings are 9 o'clock, and the buses have to have been changed to 8:30 without some of us understanding, will then be able to engage with the relevant authorities. If they don't take the buses back to 8 o'clock, then we'll then be able to change our time. We have put the 9 o'clock because we believe that it was a visual meeting for all of us. But since we've got instruction that we must come to Parliament, we have to look. You'll remember that our meeting, because of we know the traffic in Cape Town, we are going to, you usually start at 9:30 to accommodate members to come to be able to arrive in Parliament so that we don't have this disturbance. I want to apologize again. Can we push? Can I allow that we allow the advocate Mutivi and his team to present, and then the rest of the issues with regard to this meeting, we can discuss them later when the Mutivi has passed. Can I allow the Mutivi to present? The Mutivi and your team, you're welcome.
Rising on a point of order. I'm rising on a point of order. Can you please recognize me?
Honorable Masala, if you are going to talk about the meeting, I'm going to stop you. But I'm saying, I'm putting it on the agenda. I'm putting it, Honorable Masala, can I finish? I'm saying, let's allow the guests. No, the guests. I'm saying the proposal is that let's allow the guests to present, and we will then allow him to, after he has finished, we'll then come back to this issue.
It's an order. You can't park an order. I'm calling an order here. It's a point of order. You can't park a point of order.
I'm saying, Honorable Masala, I don't see but the order, Honorable Masala, but allow me to finish so that you can put the order, I can listen to the order. I'm saying, if you are going to debate about the meeting, I'm not going to allow it.
Point of orders.
Okay, point of order is recognized.
Thank you so much. Chairperson, we are not saying that you are wrong to come late because of transport arrangement. What we are saying is we are guided by the rules of Parliament. And irrespective of any challenge, because if we're going to accept challenges, next time I'm going to come here as Honorable Makhala and say that the meeting must not start at 9 because I've got also a problem, transport problems. So we are saying, what are the rules saying? Is this meeting still in within the rules of Parliament? Because the rules are clear. They say if there is, irrespective of anything, we need to, most especially when the chair is not available, we must elect the acting chairperson. Because you had challenges. We were supposed to elect the acting chairperson. Why was the meeting supposed to stop and wait for you until you arrive? This is the only time when we start with the meeting chairperson. This is a violation.
Thank you very much. Thank you very much, Honorable Masala.
It must not happen.
Honorable Masala, thank you very much. Thank you very much, Honorable Masala. Can I request Honorable Mutivi to present? Honorable Mutivi? So, Advocate Mutivi, you are welcome to the portfolio.
Motions, yeah. You must listen.
Honorable Masala, I've
we are
listened to
raising
you.
point of orders because you are out of order. Don't raise your emotions.
Honorable Masala.
You must rule and tell us what is the rule saying. We're
Honorable Masala. Honorable Masala. Honorable Masala. I'm saying let's allow the guests to present, and then we'll just. It's not sustained. It's not sustained.
Because you don't know what you
very much. No, it's not sustained. Honorable Masala, we don't have to exchange these words because I don't want to do other things that people do in the meeting. Please allow us to get Honorable Masala. Please don't interject with me. I'm saying if you are not happy, Honorable Masala, Honorable Masala, Honorable Masala, if you are not happy with my ruling, I'm saying your order is not sustained. I'm now proceeding with the meeting. If you are not happy, you know what to do. Let me request Advocate Mutivi.
I'm going
Honorable
to do
Mutivi, yes. Honorable Mutivi, can you
is not in order.
Honorable Musala, please, I'm asking you nicely, can we allow Advocate Mutivi and his team to present?
Asking you nicely to come down.
Honorable,
come down and be the leader.
I'm down. I'm not angry at my Musala.
Order, Chair. Order, Chair. No, look,
Honorable,
if Musala does not want to take your instructions, and she is saying she is asking you to remove her, please do that and let us continue. Because she's asking you to remove her, and we continue. Because she's not prepared to play to the rule.
Honorable Mashiru, Honorable Mashiru, Honorable Mashiru, Honorable Mashiru, Honorable Tafeni, Honorable Tafeni, can you remove Honorable Tafeni? Can you remove Honorable Viogazi? Honorable Viogazi, can you remove Tafeni in the meeting?
Viogazi is the secretary of the portfolio.
Yes.
Honorable
Viogazi, Viogazi, can you remove
meeting?
Honorable Viogazi, can you remove Honorable Tafeni in the meeting? Can I then ask Advocate Mutivi to proceed?
Chairperson.
No, you know.
May I please address you? Please, I'm not fighting with you. May I please address you on a point of privilege, Chair? Chairman. Nikombela kuvulavula. Chair.
You can proceed, Honorable Nkwezi. Every time you speak, or a chairperson just keep quiet.
No, the chair is having challenges. This is not a good day for the chair.
No, Honorable Nkwezi, you are recognized?
Yes, Honorable Chair, with due respect, Chair, I think that we avoid situations where we use the iron hand in dealing with our meetings. Chair, that you spoke to the secretary of the portfolio committee that the meeting will be starting a little bit later. The secretary did not inform. In other words, a new notice was not issued that the meeting would be starting late, so that members then prepare themselves for that. Therefore, I am saying that that's the reason why I was asking you, is the meeting still in line with the rules? Because we never received a new notice, and it's not like maybe we want to fight or what, or we don't want the meeting to proceed, but just to be, very calm, address this thing properly so that in the future we prevent things like this. Because really, we come and go one day, Chair.
Honorable Ngwezi, I hear you. I'm saying, honorable members, we have invited the guests. Let's allow the guests to present, and then we can then remain in discussing this issue, because it's a problem to all of us. Even to me, it's a problem. So can we allow Advocate Mutivi to present, and we deal with the matter later, honorable members? That's what I've indicated. I'm not saying let's not talk about it. I'm saying let's allow Honorable Advocate Mutivi to present first. Honorable Advocate, you're welcome with your team. Can you take us through?
But my chairperson.
Thank you very much, Honorable Chair.
Honorable Mutivi, can you please wait? We are still
Okay.
sorting issues
Okay.
here.
All right.
Chairperson, this is not how we deal with things in Parliament. This is not how we deal with things. There's an order. You need to tell us if the order is sustained or not. You can't just pack the thing and said we must wait until we must wait for the consent. If what you have done is correct or is not correct. We are not saying you are wrong. We are saying the secretaries did not tell us anything. That's why you see this confusion. If the secretary sent a notice and said that there is no transport, the chairperson is going to be late, she's asking for the meeting to be at 10. We were all going to go and do our work, and we come back at 10. We've been waiting here, waiting for you for an hour to come and start this meeting. So I don't see the problem why you don't just address this issue. And we know from now onwards, we just give us a direction. This is how it must happen. It will.
Honorable Masala, please, who has appointed? I'm saying let's allow Advocate Mutivi to present. We'll remain discussing the issue unless if you don't want the meeting to proceed.
No, we'll never
allow Honorable Masala, please. Honorable Masala, please. Honorable Advocate Mutivi, can you proceed?
Now, thank you very much, Chair, Honorable Chairperson, honorable members. We appreciate the opportunity to come and present to the honorable members around on our investigation into the Department of Water and Sanitation. I am Andy Mutivi. I'm the head of the Special Investigating Unit. I'm going to introduce the colleagues that are with me.
Chairperson, point of order, Honorable Mutivi, wait. Chairperson, Honorable Tafeni is being removed from the system. Can we get the reason why she's removed? She needs to be part of this meeting.
Honorable Masala, I've requested Honorable Tafeni to not to interject.
You are also gonna be removed, Mohlale, man. We've been waiting and waiting and wasting
Honorable
time.
Honorable Mvana, you are out of order. The chairperson
You
did not give you any permission.
You two are out of order.
Honorable Mvana.
You need to bring Honorable Tafeni back.
Mvana, you are
No. We are also going to remove you guys. It's out of order.
You are not the chairperson, Honorable Mvana. You are not.
I am not. That I know.
Remove us.
Who gave you permission to?
Honorable Tafeni, you did not give a warning.
There's no need for warning. We all know that.
How you operate.
Anytime you want to.
We must never allow the meeting to be held at ransom by people, whether in group or as individuals. And honestly speaking, officials of this portfolio committee, when instruction is given to remove people, please remove them, because people are here to stall us.
Who recognized you? You're out of order. Who recognized you?
Who recognized you when I'm done? Why do you think we are now on a letter?
You must also be removed. Me and you must be removed if that is the case.
That's fine. Let the person do that if you think that is the case. But I'm calling order on yourself.
Who recognized you?
God recognized me.
Okay. You must be removed because there's no God here.
God is always here. But Chair, please, man, please, can you continue the meeting, man? We can't be all that ransom by people here.
But you must bring Honorable Tafeni back.
This thing I was saying before the chair came.
You must bring Honorable Tafeni.
They always
back.
hold meetings using her emotions, and this thing is wrong. It's wrong. We had to wait for the chair when she was wrong, but just for a small thing, the honorable member must be removed because you have powers to do so.
Honorable Ngwezi, please, let's allow, why do you interject when the advocate is presenting? Can we allow him to present, and then we will engage on the matter of the chair after he has finished? That's what I'm saying. So can we proceed, Advocate Mutibi?
Chairperson.
Honorable Musala, can we allow Honorable advocate to present? Honorable Safeni, I've requested him to stop, he continue. I've requested her to stop, he continue. I've given 2 warnings. So can we proceed? And by Honorable Safeni, by the law, is not even the member of the committee. I cannot allow a person who is not a member of the committee to stall the meeting. It's not a member of this committee, as far as I'm concerned. Can we proceed,
No,
Honorable
Advocate? We'll talk to our chief whip, because now you are talking something else. Honorable Kafeni is a member of this portfolio committee.
No,
a member of this.
No, you have got 1 member here.
And
one member. One.
So
he's
you
an
cannot
alternate member of this portfolio committee.
Yeah, alternate comes in the absence of the member.
Honorable Mashiku, let's allow.
No, but the rules allow members to attend any portfolio committees.
No,
yeah, but
just that they don't have powers to vote. No, you must not mislead us here. You must not mislead these members.
Point of order, Chair.
Hey, you know what, Honorable Ngwezi, Honorable GM, can I allow Advocate Mutibi to proceed with the presentation?
You are saying Honorable Chafen is not a member. You removed her because she's not a member.
Wait, no, I'm saying
this up. We can't
be a member.
Threatened by you. You removed her because you are saying she's not a member.
No, Honorable Musala, I've warned her several times. We continue.
No, but it is exactly what you said here. You are on record.
The record.
No, but you are lying, Mr. Roman. You are lying. You're telling lies.
It's unparliamentary to say a member is lying.
You can't
withdraw that, Mashiko. Withdraw that. It's unparliamentary to say a member is lying.
No, Mr. Ngwezi, please, can you?
Mashiko must withdraw that.
No,
it's unparliamentary to say an honorable member is lying.
Honorable Mashiko,
so Mr. Mashiko must withdraw that.
No, but you have not raised even a hand, Honorable Ngwezi. There is a system to raise your hands. And you're just talking now. You are joining the rest to disrupt the meeting. Can we proceed with the meeting? We'll discuss these issues, honorable members.
Honorable Chair, may you please address me on this matter?
I'm going to allow.
May you please recognize me, Chair, on a point of order?
Okay,
Honorable Chairperson, I heard Honorable Member Mashiko addressing the Honorable Member Muhlala to say that she is lying, and that word is unparliamentary. So I'm requesting Honorable Member Mashiko to withdraw that on record, as the rules say.
Honorable Mashiko, can you withdraw?
I'm not sure whether it is indeed unparliamentary when somebody lies to say is lying.
No, but the parliament rule says lying. You can't say it's lying, you rather say it's true. You must use other words. The lie is not acceptable in terms of the rules.
No, if that's the case, I withdraw.
Thank you, Honorable Mashiko. Honorable, can we proceed? Advocate Mutibi?
Good morning, and Honorable Chair and Honorable members. Once more, let me thank the Honorable Committee for the opportunity for SIU to present on the investigations that we conducted, some of them still continuing in the Department of Water and Sanitation. As I indicated, my name is Andy Mutibi. I'm the head of the Special Investigating Unit, joined by my colleagues, Mr. Keiza Khanyaho, who's the spokesperson for SIU. I'm also joined by Mr. Leonard Lekgetho, who is the Chief National Investigating Officer. This investigation falls under his portfolio, and the lead investigator in this investigations is Mrs. Gina House. She will be taking us mainly through the presentation. Without further ado, we're going to proceed. Next slide. Let me also just greet the Deputy Minister of the department. Thank you very much. Next slide. The presentation covers the legislative mandate of SIU, including how we reach our outcomes, operating model. Then we will go straight into the proclamations relating to the investigations. We'll cover the status and outcomes of the investigations. You'll notice that we have really tried to do a very comprehensive investigation, since it's really the first time that we present to this honorable committee on the investigations we have done in the department. So we've sought to be as comprehensive as possible. So we'll cover the investigations that happened at Mhlathuze Water Board, various allegations at the Department of Water Affairs, and the awarding of contracts to LTE Consulting by the Lepelle Northern Water and Gauteng Department of Human Settlement, the awarding of contract by Department of Water and Sanitation to SEP and Umgeni Water, and also cover the Tugela Hudertro Water Scheme investigations. And we've since received new allegations. We will cover those allegations briefly. Next slide. This is the legislative mandate. I won't go into detail with it. The work of the special investigation is empowered by the Special Investigating Units and Special Tribunals Act of 74 of 1996. As our vision, we would like to be the state's preferred and trusted forensic investigation and litigation agency. In so doing and achieving our mission as the preferred service provider, we work together with other agencies in the fight to eradicate corruption, malpractice, and maladministration from society. Our major functions on the left-hand side, bottom, include investigation of corruption, malpractice, and maladministration. We also institute civil litigations to recover the monies that may have been lost by the state institutions. In terms of the powers in the middle, we do have the powers that are provided for any law enforcement agency: powers to subpoena witnesses, powers to search and seize, and also to interrogate witnesses under oath. And this all we do once the proclamation has been issued. Outside of our mandate, on the right-hand side, on the bottom, SIU does not have the right, the mandate or the authority to prosecute. In that event, and I'll get that into the next slide, where there's a need to prosecute, we then refer to National Prosecuting Authority. You'll also see in the presentation that we'll be mentioning referrals for disciplinary action, which we refer to the accounting officer of the department. By law, is the accounting officer who should take disciplinary actions, but we do monitor those referrals. As we indicated, we work closely with other law enforcement agencies. Next slide. Right, as we investigate, we seek to reach certain legal outcomes. And those legal outcomes are, once we reach a stage where evidence is gathered and the evidence points to irregularities. And the irregularity requires, if it's a procurement-based irregularity, we would then seek to cancel the contract and recover the money that would have been lost by the department. That we do through the civil litigation process. We do it in SIU name, but more often we also include the department to join the civil litigation as a co-applicant. And recently, the president proclaimed the establishment of the special tribunal, and that we did simply because we had noticed that in the ordinary high courts, the court roll is too high, and this special tribunal is really assisting in fast-tracking the civil litigation process. The second column, where the evidence finds that there is criminality, we then refer to the National Prosecuting Authority. We also, in many instances, work closely with the Asset Forfeiture Unit, which is part of the NPA. I indicated that this the third block, evidence of misconduct. We refer that to the accounting officer to take action. We also refer part of our evidence to other relevant authorities. In this regard, if we find, for example, that a certain service provider has not complied with the income tax legislation, for example, we then refer those to the SARS, or where there's issues with the directors of the state institution, we refer that to the Institute of Directors, as the case may be. And of course, at the end, as required by law, the report of the SIU is presented to the president. At the bottom there, honorable members, while we at the end report to the president, all of these actions, they do not wait for the report to the president. We action when evidence is picked up, we immediately action that to achieve all of these outcomes, simply because we would like action to be taken as quickly as is possible. We also indicate there that particularly on the disciplinary processes, we normally find that government officials resign in the face of disciplinary process being instituted. So the point we are making at the bottom there is that once that happens, we will pursue officials who are employed elsewhere within government service when they resign from the department to avoid disciplinary process. That phenomenon, we have observed it widely, but we have already taken into account that there are provisions in the Public Service Act that enable us to follow the employee wherever he could be. But in the instance that they resign totally from the government, of course, the employer-employee relationship would have been terminated, but we do pursue them on the criminal action, we pursue them on the civil litigation to recovery. Next slide. As we do our work, Honorable Chair and Honorable Members, these are the skills that we have in SIU. These skills are equivalent to any forensic investigating company, whether it's a private company or any other company that does forensic investigation. So we do employ forensic data analytics, forensic accountants, forensic investigators, civil litigators, forensic legals, and cyber forensic skills. So we are satisfied that as we conduct our work, we conduct it with the requisite skills so that we can produce quality outcomes. And in this regard, we can compete with the private companies, and that is why we would like government to prefer us when there's a need for any forensic investigation. Next slide. Chair, at this stage, I'm going to, with your permission, pause and hand over to my colleague, Ms. Gina, who can now go dive into the proclamations and the investigations we have done. Thank you kindly. I'll hand over to Gina. Thank you.
Thank you, sir, and morning, honourable members, the Deputy Minister and the DG of the department. I'm just introducing myself quickly, and then I'm going to switch off my video so that I can our presentation doesn't lag. Great, we'll get started. The proclamations that we're going to be discussing cover the period from 2008 all the way up to last year, so it's quite an extensive period. There are in total 6 proclamations, 2 of which have had extensions being given to them. So we'll be going through from the oldest to the newest proclamations. Sorry, the presentation tends to stick a bit. All right, I believe you have all got a copy of the presentation as well. I'm jumping to slide 9 now, which is a general overview of all of the proclamations and the outcomes that we have done over the period. As Advocate Matibi just set out all the different outcomes of the SIU, we've taken that same template and shown a summary of the outcomes on all of these proclamations that have been investigated. In terms of civil litigation, we have got 5 matters that are in court already. The Vuvani pipeline matter, Gauteng human settlements, Lepelle Northern Water in respect of the LTE contract, the SAP contract awarded by the Department of Water Affairs, as well as a second action at Lepelle Northern Water against Mr. Lehodi, the former CEO, as well as 2 of the officials working there. We've also had a total of 7 AFU referrals, 36 referrals to the National Prosecuting Authority, 25 disciplinary referrals, of which the department has made good progress in addressing these. 3 officials dismissed, 1 final written warning, and 4 resigned. Then we have had 20 referrals to SARS and 3 to the Construction and Industry Development Board. And then there's a summary of all the presidential reports that have been presented to the Office of the President for these proclamations. The 2008 one is the final report for Mhlathuzi, then 2 reports in respect of Proclamation R54, and 2 reports in respect of Proclamation R22. Then we will get into the detail of all of these now as we go on. As Advocate said, it is quite a long presentation, and the purpose being that we can fully appraise the committee of everything that has occurred. So Mhlathuzi Water Board, this is one of our first matters at the department, or involving the department. This proclamation was issued on the 4th of September 2008. And there were 2 main issues that were covered in the proclamation there, and that was the procurement of services by the Water Board for the repair, maintenance, and inspection of underwater pipes that were conveying effluent from the Mondi Business Papers plant into the sea. The second leg of the proclamation was procurement of goods and services from various entities by the Mhlathuzi Water Board, and then any potential prospective interests that members of the governing board of Mhlathuzi had in respect of the above contracts. Going on to the following slide 12, this sets out the actual focus areas of what was investigated in Mhlathuzi, the use of advanced payments by Mhlathuzi. The second bullet, the failure to settle contractual obligations, which resulted in losses suffered to the Water Board. Non-compliance with prescribed procurement and tender procedures, unlawful or constructive dismissal of staff, which resulted in financial prejudice and losses to the board, the use of resources for private business purposes that belong to the Water Board, the financial prejudice and losses suffered by Mhlathuzi as a result of the sale of houses owned by the Water Board, as well as the failure of the board to rent out houses at a market-related value in the absence of a control system. Going on to slide 13, we now look at the rest of the focus areas there. There was also fruitless and wasteful expenditure that was investigated, and this was in respect of a value chain analysis that had to be conducted by consultants on behalf of the board, but never was finalized. And then also a collapse of an electronic records management system that had been introduced, and a project undertaken to value the assets at Mhlathuzi Water Board. The last 2 focus areas are the irregular expenditure in respect of security guards, that were appointed to guard the house of the Chief Executive Officer, as well as excessive spending on travel accommodation and other expenses by members of the governing board at Mhlathuze Water. A summary of our findings there: the SIU found that the correct SCM processes were not followed. Controls and policies in place were not sufficient to mitigate the risk of financial losses that were suffered. Documentation critical to the investigation was either lost or destroyed negligently or intentionally, and this hampered our investigation. The Water Board failed to keep records of financial transactions, which reflected that 9.9 million of payment vouchers could not be traced. The majority of contracts for a tender awarded totaling over 19 million rand were not found or did not exist. The entity failed to protect its records and contravened the Public Finance Management Act as a result, and they failed to enter into written contracts with suppliers and thereby contravening the Water Act. The outcomes of the SIU investigations there: a criminal case of fraud and corruption was opened against an employee of the Water Board and the service providers who were paid gratification. The case was reported and the criminal case reference number is listed there at Richards Bay. Another criminal case of contravention of the Public Finance Management Act was opened against the board members at Mhlathuze. Richards Bay criminal case refers there as well. The DPCI are handling both of these criminal investigations. There were 3 other employees of Mhlathuze board who were implicated, and they resigned prior to the completion of the SIU's investigation. During the period of our investigation at Mhlathuze, which was January 2004 to September 2008, there were 2 different boards sitting. The SIU did its final presidential report, and that was submitted in April of 2013. That's in respect of Mhlathuze. We now move on to the next proclamation, R54 of 2012, and this is the general proclamation at the Department of Water and Sanitation. Slides 17, 18, and 19 set out our mandate, which is what we were instructed to investigate in terms of our proclamation. I'm not going to go through that in detail. Slide 20 deals with the background here. In respect of this proclamation, it was published on the 21st of September 2012, and the SIU conducted the investigation into approximately 34 allegations, all of which were completed and had significant outcomes and successes. The investigations were completed and reported on in the presidential report, which was submitted on the 15th of December 2016 to the presidency. Shortly before finalizing that report, a new allegation was received in respect of procurement processes relating to the Vuvani steel pipeline, which the SIU commenced as it was covered under that proclamation and ran as a separate project. The SIU presented our final presidential report to the president on that Vuvani investigation in October. Moving on to slide 21, the status and the progress on the SIU's referrals. As a result of our investigations, there were 58 different referrals made in respect of the outcomes, and these are all detailed in the slides that will follow. The SIU regularly follows up with the National Prosecuting Authority, NPA, to determine the status of the referrals made to them. And to formalize feedback, the SIU and NPA have signed a memorandum of understanding, and the NPA has also appointed a dedicated capacity to track progress on all SIU's criminal referrals. We continue to pursue these matters and to see them through to prosecution. The SIU also meets very regularly with the department's internal consequence management team, which is made up of HR, legal, and internal audit, and liaise with the acting DG to obtain regular updates on the status of our disciplinary referrals made by the SIU. And we can say that we're having very good working cooperation at the moment with the department. Some of the general procurement findings before we get into the details of the matters in respect of this proclamation, R54 of 2012. The procurement of goods and services by the department, which were not fair, transparent, or equitable, and the conflicts of interest in respect of department personnel. In respect of the above, the SIU found evidence during the course of the investigation that indicated fruitless and wasteful expenditure, irregular expenditure, fraud and theft, corruption, officials who appear to have defrauded the department by being complicit in the manipulation of procurement processes concerned to their personal benefit, and contraventions of the Preventing and Combating of Corrupt Activities Act. Further general findings in respect of the procurement investigations include contraventions of the Public Service Regulations Act, as well as dishonesty and fraud in terms of contraventions of the Code of Good Practice for Public Service. Getting into the details of the matter now, one of the first matters we will cover here is in respect of Mr. Senekwane. The SIU assisted the department with oversight and recovery of monies in respect of a SAP consultant who was on contract with the department. In respect of this matter, the criminal prosecution was then fast-tracked. The accused was charged and convicted on the 13th of July 2012 of 3 counts of theft to the value of 2.8 million rand. In essence, what happened is he simply transferred monies from Water Affairs into his personal bank account using the access that he had to the SAP payment system at DWS. In terms of his criminal case, he was sentenced to 7 years imprisonment. The SIU pursued the civil recovery of the monies by way of a court action, and we successfully obtained a default judgment for the full 2.8 million. Unfortunately, there was no actual recovery as Mr. Senekwane's business was liquidated and he was in jail serving his 7-year sentence. Another success was the Sundays River Valley Municipality. Here, the DWS funded an 18 million rand upgrade to the Patterson Bulk Water Supply Project in the Eastern Cape. This was done via the Amatola Water Board, who used the Sundays River Valley Municipality as the implementing agent. The SRVM failed to utilize the funds correctly and was unable to account for 7.9 million of the capital it had been granted, and instead used it to pay salaries within the municipality. The SIU was instrumental in assisting the department and declared a formal intergovernmental dispute. And in February 2014, the SIU attended the mediation and a repayment agreement was secured for the outstanding balance of 5.8 million. We continue to monitor those monthly installments of these monies and successfully recovered 5.8 million rands worth of cash for the department. We're now getting into the detailed outcomes of the conflicts of interest investigations. These are officials who have done business with the department and either failed to declare or did not have permission to do business. And these officials were identified as a result of a data analysis that the SIU performed with the assistance of the department. So here are the employees that are listed. We've also included their actual rank, the name of the company that they owned, the date that the SIU referred a disciplinary referral, which includes evidence and charges to the department. The charges have also been recorded there that we suggested be brought against the official, as well as the value that's involved in each of the transactions. And then the status that has been obtained from the department as of the 10th of June 2020. So in respect of Ms. Lakaba, the first one, the official was not charged and the matter was closed. In respect of Mr. Nkuna, he was dismissed from the department. And in respect of number 3, Moshidi, she was also not charged and the matter was closed. Moving on to slide 27, Nancy Motebe, there were charges of fraud brought against her and she resigned from the department before the matter was finalized. Simpiwe Qingwa, he also resigned from the department, also charges of fraud. And Margaret Malaza, also charges of fraud, and a hearing date is busy being scheduled for this matter. The department had some delays and had to stop their disciplinary processes due to lockdown, but they are in the process of reallocating hearing dates for those matters that were affected. Number 7 on the list, Matabula Amos, he was found guilty and received a final written warning and 3 months suspension without pay. Mahlodi Ramenyeme, the official resigned on the 31st of July 2017, and Alex Nkane, the official was not charged and the matter was closed, and he then later resigned after that decision in any event. As stated at the bottom there, the total that had been paid by the department to officials that did business with the department through their own companies was 8.9 million rand. That is the conflicts of interest investigation outcomes. We now get to the actual SCM investigations. These are different matters that were more particularly referred to the SIU by the department. And here again, we deal with the names of the companies that most of these officials had, as well as outcomes that are listed here. We're on slide 29 at the moment. So in respect of these matters, and as Advocate Matibi said earlier, and the first case here, Ms. Kuluse, is an example where the official resigned from the department and the SIU, working closely with the Public Service Administration, managed to trace the official, and the disciplinary was referred to her new employer and at DSD, and the disciplinary pack was referred to the HOD at that department, and we continue to monitor progress on action being taken there by her new employer. In respect of Mr. Lekuane, the same situation there. The official was traced and disciplinary was referred to the HOD at Environmental Affairs after he left the Department of Water. Ms. Letsau, the matter has also been reopened and a new hearing date to be decided on there. Sarah Tema, the matter is being further investigated and feedback to be provided between the SIU and the department in order to bring conclusion to that matter. Ms. Tefu finalized with a final written warning. Ms. Mda, the official was not charged and the matter was closed. That was a decision taken by the department. Now, again, in respect of the SCM investigations, here we look at the other outcomes from the SIU. In particular, here we list the criminal referrals in the second column, the referral for civil or AFU recovery, the disciplinary referrals just reiterated, and any VAT referral there. The last column also gives the updated status on matters where we have received SAM. So 3 criminal referrals in respect of accommodation services and BOTC trading, and the value that was sent there. These were all AFU referrals that were made here because at this stage the SIU was not able to litigate in its own name, and we relied on the AFU to do civil recoveries here. There were, in respect of the second matter and Domani training, there were 3 criminal referrals, AFU referral for 354,000 and 2 disciplinaries. The timber and shutter boards that were supplied by Metric Industrial Supplies, 3 criminal referrals, and there was civil litigation by the department in respect of a 30 million rand contract that was going there. Booker Management and Projects, 1 criminal referral, AFU recovery for 176,000. And in respect of all those matters, the NPA dedicated capacity is tracking the progress, and we continue to communicate with them to get updates. Further matters where we've referred, the appointment of 86 contract workers for expanded public works program. There were 3 criminal referrals there and 1 disciplinary. Payments made to TWM projects, 2 criminal referrals and AFU referral for 1.6 million and 4 disciplinaries. And in this matter, the prosecutor has been appointed to proceed with the prosecution of those 2 individuals. Night Breeze of Sunder Trading, this was an official who did business for 6.2 million with the department, plus another 653,000. And in respect of this matter, the NPA dedicated capacity is tracking the progress of it. The last criminal and AFU referrals are listed here. Chief Morris Business Enterprises was also an official of the department, and there were 2 criminal referrals there and an AFU recovery for 678,000. The NPA has advised there's sufficient evidence and they are proceeding with the prosecution of that matter. Then the 10 conflict of interest matters that were dealt with earlier, all officials of the department have also been referred for criminal investigation and prosecution. And then there were duplicate payments also made by the department, which were referred to SARS for further action by SARS in respect of possible VAT irregularities. So that totals 28 criminal referrals here, 17 disciplinary referrals and 13 SARS referrals, and a total of 40-odd million that had been either through AFU or the department's own action in the civil courts to recover monies. Some of the challenges that the SIU had, and you'll notice some of the dates that the disciplinaries were referred versus the outcomes, there was quite a gap. At that stage, the SIU wrote to the previous Acting Director General of the department in October 2018, requesting reasons for the delay in the implementation of the SIU's recommendation to discipline these officials, which in some instances was in excess of 4 years. A concern was also raised regarding disciplinary matters that had been closed, where there were representations made by the officials without consulting the SIU regarding evidence to rebut those representations. The SIU also wrote to the DG of DPSA to inquire about officials that have resigned and to track them where they may have taken up employment in another government department. In terms of Section 16B of the Public Service Act, and Advocate has already dealt with this, the accounting authority may refer disciplinary evidence to the new official's accounting authority to take action. And we've given two examples here in terms of the DCs against Ms. Kaluse and Mr. Lekuwane. Now getting into the Vuvani pipeline matter, the SIU site visit made the following observations in terms of the service delivery of this contract, which was observed in late 2018. There was no water going through the pipeline and the communities were still not getting any benefit. 3 kilometers of the pipeline had been damaged and not repaired. There were parts of the lining inside the pipe that were loose and needed to be repaired. This was confirmed by the project managers, Big in Africa, and that the department at that stage didn't have funds to pay Escol Construction, who was the appointed contractor, or Big in Africa, who were the project managers. Further project management issues identified by the SIU during our investigation. In respect of this, the the department's supervising engineer, Big in Africa, alerted the department timelessly to risks involved. The officials cited the promotion of BEE as justification to regularly split the tender and thereupon extend the contractor's contract despite Biggins' advice to the contrary. The official in this process, the official involved here is being disciplined. There was failure to comply with the public service management and its regulations regarding supply chain, failure to heed the professional engineering advice, poor project management and oversight by the department, and poor financial management and record keeping. The status of this investigation at Vuvani, the SIU has completed the SCM investigation. The final presidential report was submitted to the president in October 2018. The contract, which was awarded in 2012 with a value of 50 million rand and a completion date of 45 weeks, a total of 29 million had been paid to the company involved, Escol Construction. Subsequent to the award of the contract, Escol from July 2012 onwards failed to perform on time, and instead of enforcing penalty clauses, the department unlawfully entered into supplementary agreement which made provision for the waiving of these penalties. In addition to this, the agreement also provided for a 16 million rand advance payment to Escol Construction with a view to improve its cash flow. The extension is alleged to constitute a complete disregard and contravention of the provisions of the original contract and the PFMA. Further status: on the 9th of February 2016, the SIU advised the then DG of the department not to proceed with the payment of 8.5 million to Escol Construction. The DG accepted our recommendations and instructed both CFOs not to approve the payment to construction and thereby saving the department 8.5 million. The SIU further advised the department that the 13 million paid to Escol Construction under the premise of it being an advance payment was irregular as well as fruitless and wasteful expenditure. Further outcomes of our SIU investigation: a NPA referral of evidence pointing towards fraud involving the company, Escol Construction, and the director on the 18th of September 2018. A disciplinary referral of evidence pointing towards possible misconduct of the DDG at the water trading entity was referred to the department on the 30th of July 2018. In respect of this disciplinary hearing, it was conducted and finalized, and the DDG, Ms. Martia, was found not guilty. We have liaised with the department and have been advised that the department has filed a review application at the Labour Court. The misconduct that was involved and that the SIU identified was gross negligence in the performance of her duties, contravening various prescripts, including PFMA, the Constitution, Treasury regulations, the department's SCM policy, and the CIDB Act. The final outcomes on Vuvani also include 3 SARS referrals against Escol Construction and 2 water affairs officials for tax discrepancies and unexplained income. SARS is pursuing the matters as per a letter received from them in July of 2019. We also referred evidence to the Construction and Industry Development Board in February 2018, pointing towards fraud committed by the company in the grading process. A follow-up letter was received from the CIDB on the 17th of July, confirming that the CIDB is conducting their inquiry. Then, very importantly, our civil litigation. The SIU has instituted civil action by way of a claim for damages to the value of 140 million rand, which was amended to 95 million rand. And the particulars of claim were amended following an exception that was raised. The summons was issued on the 6th of February 2018 in the name of the SIU as the plaintiff and issued out of the High Court in the Gauteng Division, and Pretoria case number refers. The parties involved are Escol Construction, Dan Lucas Sikosana, the director of Escol, Zandile Yvonne Mate, Nima Katini, the DDG at DWS at the time, and Mpho Joseph Mofokeng, the former CFO at DWS, who has since left the department. The status of the civil litigation, following an exception raised by one of the defendants, the amended particulars of claim were filed in July 2018, and the defendants responded to this with amended pleas, which were filed in November of 2018. To refute the defenses raised, which are of a highly technical nature, an engineer was procured to perform additional investigations and to revise the quantification of the damage suffered. This process resulted in a small delay, but the engineer has since provided his preliminary report in this regard. The civil litigation is continuing, and the appointment of a judge in respect of the case management process should be done soon. And the third defendant's attorneys has withdrawn from the records, and the third defendant's appointment of a new attorney and the response to the SIU's notice is expected by end November 2020. Then getting to more current investigations, we will first deal with Lepelle Northern Water, Proclamation R22 of 2016. The mandate is covered on slides 46 and 47. And this proclamation covers the appointment of LTE by both Lepelle Northern Water and the Gauteng Department of Human Settlements. So there were two contracts for us to investigate at two different entities in respect of this proclamation. Some of the SIU's project management issues that were identified during our investigation, it reveals serious maladministration and malpractice, in particular failure to comply with public service management and regulations, failure to heed professional engineering advice, poor project management and poor project management oversight by the department, and poor financial management and record keeping. Our observations of the state of delivery in Guyana, which was observed in late 2018 from a site visit, there was no water connection. In the Guyana project, the price for boreholes, including the treatment plant, was between 1.2 and 1.4 million per borehole. The company that was responsible for the geotech services and the managing and drilling of the boreholes indicated the normal price for installing a borehole, similar to the ones in Guyana, was actually around 100,000 Rand. Then the company that supplied the water treatment plant indicated that the normal price for a water treatment plant to go with a borehole is between 195 and 295,000 Rand, significantly lower than the 1.2 to 1.4 billion being charged above. We also observed that the water treatment plants had worked for only a month. In respect of Lepelle, we also undertook a value for money exercise, utilizing skills of engineers in the field. This was a massive project, and they went and reviewed all the work completed in the Guyana area in respect of this contract. The appointed engineer has submitted a draft report, and it's currently under review. In November 2019, the SIU conducted a search and seizure at Lepelle Northern Water in order to obtain documents that were needed for this value for money. We have not received the greatest of cooperation in the past from Lepelle, and I'll detail that a bit later. From the documents that we seized, it was clear that Lepelle continued with the services of the contractor after they received the summons, and the contract value went from 2.2 billion to 3.2 billion. The SIU will be adding that additional expenditure of approximately 1 billion Rand to the current civil litigation that is in the High Court for recovery. The value for money investigation leg is still ongoing. The SIU's SCM investigation has been completed, and we found that the contract was irregularly awarded. As a result, result, SIU issued summons on the 26th of November 2018 in the High Court Limpopo Division, Polokwane. The civil litigation is an action to set aside the contract to the value of 2.2 billion, and the SIU alleges that the contract was unlawfully and irregularly concluded. As stated on the previous slide, that value will be increased to 3.2 billion. The parties to the litigation are the SIU against Lepele Northern Water Board, Cato Consulting Civils, Zambezi Engineering, Mopane District Municipality, and LTE Consulting, and the Department of Water and Sanitation. The parties exchanged the final pleadings, and the court file has been paginated and indexed, and a counsel has been briefed to file heads of argument, so the matter is proceeding well. The SIU will, after filing the heads of argument by all parties, apply for a hearing date. We have advised the department to proceed and claim monies due despite the threat to review the SIU report, which to date has not transpired. Slide 52. In respect of the investigation, the SIU's also referred evidence to the Construction and Industry Development Board. These are further outcomes on our investigation, and that evidence points towards a contravention of the CIDB Act on the 6th of December 2017. The current status of that referral is the CIDB is conducting the inquiry, confirmed they're going to conduct the inquiry, but have placed it on hold pending the outcome of the High Court application proceedings. Disciplinary referrals were made to LNW in respect of the manager planning at LNW on the 20th of September 2018 for collusion, fraud, and forgery. A disciplinary referral also against the former CEO of Lepele Northern Water in February 2018 for negligence and contravening the PFMA. Mr. Lahori has since resigned from Lepele Northern Water in September of 2020. As a result of this, the SIU brought an urgent court application in the Special Investigation Unit's Special Tribunal, and Ms. Lahori's pension was frozen, case number GP 10 of 20 refers. The main and separate action was also instituted against Mr. Lahori and 2 other officials to the value of 1.1 billion rand. Additional outcomes of our LNW investigation: NPA referral was made on the 3rd of April for a contravention of the PFMA. Further NPA referral was made in respect of an official in September 2018 for collusion, fraud, and in particular forgery. And we have submitted an interim presidential report to the Office of the President on the 30th of October 2018. The corruption investigation in respect of this matter is still ongoing and has been extended as new evidence has been uncovered and needs to be investigated to its logical conclusion. An extension to the proclamation was applied for and granted in this respect. As a result of that, Proclamation R27 of 2019 on slide 54 was issued, and this is an investigation in the appointment of Blackhead Consulting in respect of the raising of the Tsinine Dam. Now, our investigation has just commenced into these, and it is ongoing in respect of the above matters as listed there on slide 54. Getting back to Lepele Northern Water, the challenges experienced there by the SIU, as I touched on earlier, the former CEO, Mr. Lahori of LNW, used the state institution's funds to delay and challenge the SIU's investigation. 2 examples are quoted here. There was a review of all contracts and investigations conducted by an audit firm appointed by LNW at the instructions of the former CFO, pretty much doing a duplicate investigation. And then a multitude of lawyers' letters were sent to the SIU during the course of our investigation. Further to this, Lepele Northern Water applied for an interdict against the SIU to prevent the unit from conducting further investigations. Mr. Lahori and the LNW board brought interdict proceedings against the SIU for orders in the following terms: that the purported investigation by the SIU of private and personal financial affairs of Lahori is not authorized by the proclamation, and that the investigation by the SIU of the private personal affairs of Lahori is in fact unlawful and unconstitutional, and that the SIU is directed to desist and refrain from carrying on with the said investigation. That is what they were requesting in their interdict. Lepele Northern Water Board withdrew as the second respondent, and Mr. Lahori is now the sole applicant in this process. The parties are exchanging pleadings, and the matter is to be enrolled for hearing. Moving on to human settlements and the contract that was awarded by them in terms of the Sweetwaters project, and it was awarded as well to LTE Consulting. In respect of this matter here, the investigation is being concluded. The final presidential report was signed off on the 20th of September 2018 and submitted to the president. The SIU found that the contract was awarded irregularly and that there was corruption involving the company and the officials. The outcomes of our investigation include that we have instituted litigation in March 2018 to set aside the contract to the value of 108 million. Case number refers in the Gauteng Central Division of the High Court. The civil litigation process is underway and the parties and the department has served all parties with the record. Judge Mortley has been assigned to case manage, and the last meeting was in May 2020, where it was directed that the state attorney should furnish all parties with copies of annexures. The SIU is proceeding with drafting heads of arguments. Thereafter, the judge will contact the parties with a new date. Additional outcomes here: a referral to the NPA in respect of the former DG of Human Settlements in terms of contraventions of the PFMA. A referral to the NPA in respect of the Human Settlements official for corruption in April 2018. The anti-corruption task team is dealing with that matter. And then an additional referral in respect of 7 officials at Human Settlements and the private entities involved in the contract for corruption was also referred to the NPA, and the NPA's dedicated capacity is tracking progress in respect of that matter. Additional outcomes: referred evidence to SARS in March 2018 relating to a false tax clearance certificate of the company, as well as alerting SARS to the corruption relating to the above 7 officials and entities. SARS is pursuing the matter. 3 disciplinary charges supporting misconduct in respect of the 3 officials on the 13th of November 2017. Hearing dates were set down, however, the officials resigned from the department. Again, the SIU keeps an eye on these officials to see if they pop up in any other government service, and the civil and criminal action will, however, continue against these individuals. SIU also referred evidence to the Construction and Industry Development Board on the 10th of November 2017, and the CIDB inquiry is on hold pending the High Court review outcome. Moving on to the next proclamation, R27 of 2018. This is the contracts awarded to SAP. The mandate is set out there on page 62. In respect of this investigation, the allegations that were received by the SIU was the purchasing of SAP licenses for more than 500 million rand, which it is alleged were not necessary and done without the correct tender process, as well as a payment of 35 million rand in kickbacks. The proclamation was published on the 21st, and the SIU kicked off its work on the 21st and immediately uplifted computers and documentation from the department. Our letter of engagement set out the mandate, scope, proclamation, timeframes, and cost, which was presented to the then acting DG. A general overview has found, the SIU has found evidence that indicates that the contract value is in fact approximately 950 million rand, excluding VAT, which consists of 450 million rand for SAP license fees plus maintenance over 5 years. We further found that there was no needs analysis conducted, no budget, no environment or approval for the payments made to SAP, and a total of 285 million rand in terms of the full contract value had already been paid to SAP. Further to this, SIU found that CETA was not consulted and was required for such a purchase, and in fact, CETA had advised the department against proceeding with this contract. In terms of the 2 agreements, there was a 2015 agreement that SIU found that it was irregular and ought to be set aside. Firstly, it was entered into pursuant to a misrepresentation that the earlier 2012 agreement was due to expire in December 2015, whereas it was only going to expire in December 2016. Secondly, there was no budget for the 2015 agreement. And thirdly, the department did not comply with its own SCM policy, as well as the Constitution, PFMA, CETA Act, National Treasury Regulations, and Practice Notes. In terms of the 2016 agreement, the SIU also found that it was irregular and ought to be set aside. Here, the department procured IT-related software for entities which the department had no authority to procure goods and services, and this includes several of the water boards. The ITC and Chief Information Officer, who are the subject matter experts on IT at the department, did not support the procurement of these SAP licenses. The department nor any of its entities actually received any services, nor were any of the products or software licenses deployed by the department in respect of the 2016 agreement. And again, the department did not comply with its policies, the constitution, etc. Further to this, there was no budget, and as a result of all of this, it led to the department incurring fruitless and wasteful expenditure to the amount of the 285 million rand that was paid to SAP. The outcomes of the SIU investigation: civil litigation was launched in the special tribunal by the SIU with the Department of Water as a co-applicant. Court papers were issued on the 30th of July 2020, and the SIU is seeking an order to set aside the contract between DWS and SAP to the value of just over 1 billion rand. SIU in its papers prays for an order declaring the decision taken by the respondents or any functionary of the department to appoint the service provider for licenses for the period of 5 years, in that it's inconsistent with the Constitution, the PFMA, Treasury regulations, and the principle of legality and common law, unlawful, invalid, and of no force and effect, and void ab initio. Further outcomes in respect of this investigation: an NPA referral for PFMA contraventions of the former acting DG was referred on the 4th of November 2019. An AFU referral on the 31st of January 2020. Disciplinary referrals against the DDG was referred in October of 2019. The status of this referral is that the official has been served with the charges, and a hearing date was set down for April of 2020. A new date must be arranged for this matter, which was obviously postponed due to lockdown. A further disciplinary against the Chief Director on the 15th of June 2020, and in this matter, the department is in the process of appointing an initiator and a chairperson. Referral of evidence to the BBBEE was made in August of 2019, as well as a SARS referral in July 2019 for tax discrepancies and for verifying VAT registration. SARS confirmed that they will be reviewing that matter. We now move on to Umgeni Water, Proclamation R4 of 2019. In respect of this matter, the mandate is set out on slides 71, 72, and 73. There are 4 main focus areas in respect of the Umgeni investigation. Focus area 1 is detailed on slide 74, and this sets out 8 specific contracts that are listed there that are being investigated under focus area 1, and with a total value of 378 million rand for all those contracts that are listed there. Focus area 2 is focusing particularly on the maladministration in respect of the implementation of the contract participation goal program by Umgeni. Focus area 3 is looking specifically there at any fraudulent or corrupt activities that were conducted by the board members, officials, or employees of Umgeni, as well as contractors, suppliers, and service providers in the course of doing business with Umgeni. And focus area 4 is to determine any related unauthorized, irregular, or fruitless and wasteful expenditure incurred by the state or Umgeni, which resulted in losses suffered by either of the parties. Progress on investigations at Umgeni. The investigation is going along well, with 80% of all requested documents being obtained. Unfortunately, 20% of documents that we were looking for could not be located. We've identified all the role players at Umgeni, as well as the suppliers, interviewed 40% of all role players, and analyzed all documentation received. The team has identified a further 20 subcontractors and CPG partners that are possibly implicated. The investigation is at a sensitive stage and where we have identified persons that are possibly implicated in transgressions. We have commenced with referrals in September 2020. The referrals that have been made are listed here under outcomes on slide 77. A referral to the National Prosecuting Authority for fraud, corruption, and contravention of the Prevention and Combating of Corrupt Activities Act, as well as money laundering, contravention of the Prevention of Organized Crime Act against 7 individuals and 4 entities. The matter has also been referred to the Asset Forfeiture Unit. The SIU foresees the following outcomes being made in the next 2 months: disciplinary referrals made to Umgeni and respective officials, further criminal referrals to the National Prosecuting Authority, referrals to the Asset Forfeiture Unit, as well as civil recovery. The constraints that were experienced by the team is that the contracts date back to 2012, which is quite some time ago. There are a large number of contracts and contractors being investigated, in particular relating to the CPG partners. Some of the officials have left the employment of Umgeni Water. A lack of documentation with regards to 20% that could not be traced has frustrated our investigations. Initially, there was a lack of cooperation by Umgeni officials, but this constraint has been dealt with, and we now are receiving good cooperation. And lockdown impacted on us meeting with witnesses, but this is now being attended to using virtual meetings. In conclusion, at Umgeni, the investigation is at an advanced stage. And although initial issues were experienced with the entity, we've established a good measure of cooperation, which is assisting us in moving forward. And it is envisaged that the project end date of 30 November 2020 will be met. We now move on to the final proclamation, Tekela Khudetro Transfer Scheme, Proclamation R28 of 2019. The mandate is set out there on slides 81 and 82 as per the proclamation given to the SIU by the President. The allegations that we are investigating there is the appointment of service providers for the upgrade, that the appointment of a service provider for the upgrade was not on the panel of professional service providers. The second allegation was the procurement of the service provider for the emergency upgrade at Tekela Khudetro Transfer Scheme was irregular, and that the service provider was appointed on the pretense of emergency, which was not justifiable. The appointed service provider was paid an amount of 419 million rand, whilst the upgrade in fact had not been completed after the contract period expired in March 2019. An overview of focus areas and the investigation work that has been done, the procurement of the panel of professional service providers, the review of the SCM process to appoint service providers in terms of WP 0485 WTE, panel of professional service providers was conducted, and the investigation revealed that AECOM SA was in fact on the panel. This is the company in question, and that investigation leg is being closed out. The procurement of the service provider based on the emergency, the review of the procurement process was completed, as well as the analysis of documents, interviewing and obtaining of affidavits from relevant role players has been finalized. There are disciplinary referrals against 5 senior officials that are under legal internal review, and NPA referrals against implicated officials are being drafted for legal review as well. Once those reviews are completed, then they will be handed over to the relevant institutions. The expenditure that was incurred for the emergency upgrade, a financial analysis of the payment packs has been finalized, and interviews have been conducted and finalized, and the calculation of the potential loss is ongoing. Slide 85. On the 28th of September, this is just some overview and background of this contract. On 28 September 2017, the department awarded the contract for the emergency upgrading of Tekela Khudetro Transfer Scheme to AECOM to the value of 559 million excluding VAT. And this was for a period of 18 months. AECOM claimed an amount of 419 million from the department, and then on the 1st of February 2019 submitted a termination letter to the department before the completion of its contractual obligations. During the joint site visit between the SIU and the department, it was observed that equipment crucial to the functioning of the scheme were not on site. The incomplete work and exposure of the materials to the elements was compromising the quality and will result in the department having to replace those items and incur additional expenditure. Some items have been removed by the subcontractors from site due to contractual disputes with AECOM, and these items have to be replaced, which will again incur additional expenditure. The emergency section of the appointment of AECOM, the investigation revealed that AECOM was awarded the contract irregularly, which resulted in the department incurring irregular expenditure of 646 million. The SIU conducted interviews and obtained affidavits from relevant officials and witnesses regarding the appointment of AECOM for the emergency upgrade, and this investigation is finalized. The SIU is packaging evidence in respect of identified officials, and the disciplinary referrals are currently under review, as well as the criminal referrals. We are on slide 87. The investigation further revealed that ACOM claimed the second invoice based on its bill of quantities versus the department's tender bill of quantities. The overpayment based on ACOM's bill of quantities was recovered by the department by offsetting against part payments on the third invoice. The tender bill of quantities was ultimately used for future invoices and payments. The department confirmed that 72.69% of the total contract was paid, equating to 419 million of the 577 million, excluding VAT. The SIU is still awaiting more detailed report once the site visit at Tukela Khudetro transfer scheme with the department's engineers is conducted. On slide 88, the expenditure incurred again in respect of emergency. The SIU investigation revealed that there were assets purchased that were not used for the project. These assets were taken by a subcontractor after payment disputes with ACOM. The department was due to supply the SIU on the purchase of these assets, who they belong to, their condition and value, in order to possibly recover those funds. The investigation identified invoices and payments for work performed outside of the contractual period. This aspect is currently under legal review, with the possibility of such payments being regarded as irregular expenditure. Then looking at our outcomes here, disciplinary referrals, again, just recapping that misconduct against 5 senior officials is in the process in respect of the emergency procurement. Civil recoveries, there's been partial delivery, irregular, fruitless and wasteful expenditure. And NPA referrals. One criminal case was already registered with the SAPS, and the Anti-Corruption Task Team Act is investigating the matter, and the SIU will be referring additional evidence to support this investigation. Then that is all the current proclamations that the SIU has. We're now looking at new allegations that were received by the SIU, and in respect of these matters, again, the Lepelle Northern Water Board appears. And here we have applied, we received allegations that LNB had procured drought relief technology services and investigation services from a service provider in a manner that is contrary to provisions of the Constitution and Lepelle's procurement prescripts. It was further alleged that one of the service providers was appointed on an expedited basis without just cause, and that the procurement was not budgeted for. The SIU has assessed the allegations and has applied to the President for a proclamation to investigate these allegations. Another new matter that is brought to the SIU's attention is in respect of the Amatola Water Board. It was the same allegations are there in respect of Amatola, that they also appointed drought relief technology services and investigation services from the same service providers appointed by Lepelle in a matter that contravened the Constitution and their procurement prescripts. It was further alleged that 230 million rand allocated to Amatola Water Board for drought relief solutions, 60% of that was earmarked for the drought relief technology service provider. The procurement of both these services was not budgeted for. The SIU has assessed the allegations and has applied to the President for a proclamation to investigate these matters. Further concerns that were raised in respect of various matters. The SIU is aware of the concerns voiced in the media and elsewhere regarding the War and Leaks program, Drop a Block, the bucket eradication, and Sedibeng Water Board. The SIU has requested, received, and reviewed reports from the AGSA, Outer Parliament, and the Water Department in order to thoroughly assess the matters and the allegations around the billions of rands of irregular and unauthorized expenditure. The SIU has assessed these allegations and is now in the process of drafting the motivation to the President for a proclamation to investigate these matters. Thank you very much. That is the SIU's presentation.
Honorable Chair, honorable members, thank you very much for the time you allowed us to present to the honorable committee. The presentation, as we indicated when we started, was as comprehensive as it is, so that the committee gets a full view of what the SIU has done in terms of investigations. And as the honorable committee can see, that our view is that the investigation has revealed serious maladministration malpractices, and in some instances, possible corruption, the conflicts of interest that were attendant in the department. And our observation across the board when we do investigations is that the conflicts of interest, if they are not declared and ensured that they are monitored, it becomes a breeding ground for corrupt activities. What we are doing at the moment is to ensure that in those areas where there has been referrals, as the Honorable Committee would have seen, there has been referrals for criminal prosecution. We are engaging regularly with the National Prosecuting Authority to ensure that those prosecutions follow. We do engage with them based on the memorandum of understanding that we have, and we get regular feedback. On the civil side, the committee would have seen various cases that have been lodged, instituted in the high courts. Since the inception of the special tribunal, some matters have now been instituted in the special tribunal. And we are making sure that those matters are proceeded with. The disciplinary processes, as my colleague, Mrs. Barretta Pretorius has indicated, that we engage with the department on an ongoing basis to ensure that those who are responsible for all these irregularities and maladministration are held to account. On the regulatory authorities side, in instances where we have found that the companies did not comply with the Income Tax or VAT Act, we have referred them to SARS. In the instances where there's been contravention with the other legislations, we then referred them to those regulatory authorities. We have made several observations regarding the project monitoring, poor project management, and all of that. We assume at this stage that those observations would have been taken into account and that measures should be put in place to correct those measures going forward. As we indicated, in some instances, particularly around the Lepelle Northern Water investigation, we had to obtain an extension or an amendment to the proclamation, because as we get the proclamations, they are time-bound and there's a specific scope covered by a proclamation. If allegations fall outside of the current proclamation, by law, we are required to request the amendment so that we do our investigations within legal bounds. So the extension that we got in the Lepelle covers the investigation into possible corruption. There's a company, Blackhead, that is mentioned there. We have since discovered that it's the same company that was mentioned and implicated in the asbestos investigations that we did in the Free State. And that matter is now receiving attention of the Zondo Commission. We are working very closely with the investigators at the Zondo Commission so that we produce concerted results on that matter. I'd like to pause here once more. Honorable Chair, thank you very much to the committee. We are available now to take questions. Thank you.
Thank you very much, Advocate Mutibi and your team. Indeed, it was a very informative information from members. I'm now going to allow just to thank you again, Honorable Advocate Mutibi and your team for availing yourselves, and apologize for the delay at the beginning of the meeting. And just to allow honorable members to interact with the report, I'm going to allow members to raise their hands. There is on your device on your left, There is a 3 dotted. There are 3 dotted. Honorable Masala, can you mute your mic? I can see honor. Yes, okay. Can we have those that wants to ask question? I have Honorable Mofotu, followed by Honorable Ngwezi, followed by Honorable Mushala, followed by Honorable Mashego. With that order, as I've others, if they will decide to raise later, let's start with Honorable Mofotu and Honorable Tseke. Yes, let's do that. And Sehlwai, Honorable Mohotu, Honorable Ngwezi, Honorable Rebecca, Honorable Mashego, Honorable
Musala, not Rebecca. Point of order.
Oh, honor. But I've said honorable member. Honorable Rosina is still honorable. It doesn't change the honorability part of it. Honorable, and I've written from the gadget. Honorable Grace Tseke, Honorable Nancy Sehlwai. As I've mentioned, can we do that? Ask question for clarity and Honorable Mohotu, it's your turn.
Thank you, Chairperson. I would also like to thank the SIU for a good presentation. I'll start with my first question. What advice can the SIU give to the Department of Water and Sanitation to improve controls and policies to manage resources and risks? And what are some of the challenges experienced by the SIU in fulfilling its legislative mandate as derived from Section 4 of the Special Tribunals, ACR, and Section 32, Section 33, and Section 34 of the Constitution, specifically in relation to proclamations issued on the Department of Water and Sanitation? And then the last question is, the construction industry in the country has been riddled with allegations of corruption, not only within the Department of Water and Sanitation. Should there not be a broader forensic investigation across all departments procuring construction services? Thank you, Chairperson.
Thank you very much, Honorable Mkhoto. Honorable Ngwezi.
Thank you very much, Sihlalo. Ngibingelele ku-Advocate Motibi nethimba lakhe ahamba nalo. The first question will be that on the dismissed staff, what happens to the possible criminal charges? Are they continued or they actually stop when somebody has been dismissed? Just same as somebody is resigning, but you feel that as SIU, you still have information that you can pursue. What do you do? Because not in the country, I've seen a majority of people, when they are charged, they just resign. And I just want to understand, what does SIU do in that instance? Because people will run away from institution A to institution B because they know that maybe they can't be followed. And the other question I have is that how do you receive, or how do you receive allegations? What is the normal procedure of the SIU receiving the allegations of any matter that need, your attention. And the last question before the concern is that, are there any cases which the SIU have investigated and maybe were referred for prosecution and up to so far has not been prosecuted? And among those cases, would Advocate Mtivi be in a position to give us some? Because a lot is happening in the country, and we know that in some instances, some people who commit crime in the country have got connections, very serious connections with, either, those who have influence in the law enforcement agencies and all that. The concern, Honorable Chair and Advocate Mchibi colleagues, is based on the issue of the Mhlatuza water. I say that the proclamations were actually done in 2008, and up to so far, 12 years later, still very little has been done, and the damage in the area is such a very huge damage. And I want to plead with the SIU to actually, do something as quick as possible, because we would like to see matters of the Mhlatuza Water Board being addressed. And also there is a criminal case that Advocate Mtivi, or rather and the team has mentioned, the case that was opened in 2010, the criminal case. I say that that case has not also been prosecuted. And many cases, of course, which the SIU has actually referred. And also, Chair, to thank the SIU for the work that they are actually doing, but also, as I've requested, that perhaps something must be done. SIU can't be made to be, to do a work that must be incomplete because of other organs of the state, So as members of the portfolio committee, I think we must do something also about that, but we must understand the frustrations that the SIU has in matters that are referred for prosecutions. Thank you very much, Honorable Chair.
Thanks so much, Chairperson. Can I please request another honorable member to come in? I'm in a very noisy spot. Let me sort my situation first. I'll come after the honorable member. Thank you.
So thanks, Chair. It should be me then if Member Masala is. Thank you, Chairperson. Member Masala is asking me to speak while she's sorting herself up. Can I continue, Chair?
You can continue. The chair is cut off.
Okay. Thanks, Advocate Mtivi. A number of questions. I must first echo the sentiment of Ubabungwezi on the time in between the Mhlatuza problems thus far. The matter was recorded in 2018, closed in April 2013, but nothing is coming to the fore. And even in your report, you are not giving us work in between that time and today, whether there is something that is happening. And I think I want to echo that sentiment. And I want to thank you for the work done on Mr. Snukwane liquidating his finances and attaining your 7 years of conviction. Job well done. But in the River Valley, just starting from the River Valley downwards, you are saying there are people that were not charged even if they were found to have done something, and you are not mitigating why are they not charged, when in actual fact wrongdoings has been found. It might be that maybe your evidence is weak and so forth and so on. It is something that you can't foresee conviction. But if you can just make us aware why people are not being charged whilst you have done this investigation on them and you have found that there are some guilty things that they do. On the Lepelle Northern Water, and I was to ask that question. At some point we did get the view that the CEO of Lepelle was challenging the minister for having suspended, given a statement of his suspension or his corrupt activities, and he took the minister to court. I remember, and it was an issue a bit. And now it is confirmed that he's even resigned. But the question I want to ask there, in the report you say at some point the board itself was challenging you and the department for going into personal matters of Mr. Lukhodi and saying that you must separate Mr. Lukhodi's private work and the Lepelle Water work. Why? What was the board's view on that matter? Because to me, if they say their CEO is independent from them, but they're defending him, I don't get sense of that thing. And I take note of the fact that finally you said they have now withdrawn, he is now alone. But you must get to understand what was informing their views in the first place, because it might be, to me, it might be a question of collaboration and sleeping with the enemy in the process. And maybe you might help us. What was informing them to come to that view at some point? Starting from the Sweet Waters report downwards, Chair, there is a change of reporting. On the other institution before, you were giving us names of people and the level of convictions or the level of indictment they have. From the Sweet Waters downwards, you are no longer giving us names. I know that maybe if matters are sub judice, you are very careful to give names. If that is the case, make us aware, because it might sound a little bit peculiar that in other areas you mention names, in other areas it doesn't, and there is no reason behind why that is the case. On the SAP matter, Chair, the SIU raised that there is 500 million rand or more, which is under kickback category. What does kickback mean in this case? And how does it come to 500 million rand if a kickback is what I understand to Uguti Chocho, if I'm right? But can I make aware that what is it that you call kickback that constitutes 500 million rand? And what is then the position or the posture of the SIU on kickbacks in general, but in this one is in particular? Chair, this company from Tukela downwards called ACOM. I don't know, my understanding, my listening to you seemed that firstly, it got its contract illegally. That's the first point. And when it is not paid in time or the amount they want, it has got the tendency of getting into sites and remove material illegally from the sites of the department or the sites of the holding company in wanting to them to be paid in time. And whilst in actual fact, the writing is that they have acquired their contracts illegally. So they are just gangsters who behave like criminals legally in our institution. What is our position? I haven't heard what is it, because the issue of the water leaks, at some point we discussed it. And when we came into Parliament ourselves, there was a view we took about water leaks, and it is still written here as a challenge, which is not, which can't be accounted for. I do not get a sense of the SIU and the relationship between the ISO report and that which the department reported to us in the beginning of 2019 when we came into Parliament. Thank you, Chair.
Thank you, Honorable. Thank you,
Yeah.
Honorable Masibo. Honorable Masala.
No, thanks so much, Chairperson. My first question, I'm going to direct the department. My question is, department closes some matters at times after SIU report. Does the department have the necessary capacity to interrogate and investigate further, as it appears that Department of Water and Sanitation delays the processes or closes the matter? Is the information related to the SIU? What is the basis of the department closing matters when in some instances there are serious allegations? The other question, Chairperson, is with regards to the issue of the SAP contract. It is now taking the SIU roughly 2 years doing the investigations. So my question is, why the delays? Why is it taking time for the Special Investigating Unit to investigate or complete investigation in less than maybe a year, or in less time? The other question, Chairperson, is in the past, insufficient funding for SOE investigations hampered the progress of its work. Has the SIU investigation hampered the progress of its work? Has this been resolved, and has the SIU have sufficient funds to effectively undertake their work now? How much does one investigation cost when a proclamation is issued? Please provide us with an example of one case in the Water and Sanitation Department. Chairperson, in terms of the referrals to the NPA for criminal prosecution, is the SIU liaising with the National Prosecuting Authority to follow through processes? I concur with Honorable Nkwesi on the issue of Tuesday. 3 employees resign prior completion of the investigations. In situation like this, how do we deal with these matters? Because we can't just leave people when they've broken the laws, but we leave them because they've resigned. So what is the processes when people have resigned? What is the SIU doing? Is just leaving those people like that? Because if that is the case, people will now resign every time there's a case. When there's a case, I'm gonna resign. I know that my criminality actions won't haunt me. The other issue of Mr. Sinokwani, he is the only person who's been, I think, what is this? Who's been Luachachiwe manje. My question is, in institutions like municipalities, it cannot be one person liable for transferring of money from one account to another. Normally there are 3 signatories or more than that. What happened? How is this possible for one person to be able to transfer money from one account to another? Because if an institution, it must have 3 signatories. I transfer money, there must be somebody who's doing the approval. There must be somebody who's doing another approval, maybe 2 signatures after maybe somebody load. So what happened? Where are the others? Why is the system so weak, if I can put it like that? The last question, Chairperson, is with regards to, okay, it's what is your view of departments incorporating forensic auditing investigation unit as part of their institutions? Seems as if internal audit committees in the department don't have the capacity to mitigate risk. So I just need your opinion on this one. Thanks so much. Thank you.
Thank you, Honorable Masala. Honorable Zeke.
Well, thank you, Chairperson, and my apology, I was disconnected. Let me also join other members in appreciating the report by Ntatemo TV and his team. And I think the portfolio committee supports him going forward in making sure that we deal with all these cases of corruption and maladministration, Chair. And I think they should, SIU should also pursue all referrals, Chairperson, be it to refer to the NPA, to the departments and all these law enforcement agencies, Chair. And Chair, one of the things that I want to raise, Chair, I think we have received some reports of disciplinary actions within the department. But I think it is important now, after receiving this report from the SIU, to get a comprehensive report from the department, just to see where are they in terms of all the cases that has been referred to by the SIU Chair. This is my proposal. And on the other matter, Chair, I'm not quite sure that the TV, is it possible for government to name and shame all these corrupt people, Chair? Because there's no way that we can be able to deal with them, because they can move from one place to the other. They can move from this department to other department. They can move from this contract to the other contract, just making sure that they loot government's fiscal chair. I think there must be a way of naming and shaming them so that the public can be able to know who are the main culprits of corruption in this country, Chair. I'm raising this matter, Chair, because when you look at the entire report, majority of the people who are corrupt are government officials. And the public view corruption in this country as being politicians. And this report clearly shows you that majority of the people who are corrupt are government officials. So I think we must have a way of naming and shaming them so that we can, in future, they should not be able to be appointed either by government or public sector. On the other matter, Chair, just to join members in terms of SIU tracking some of the investigation, When you look at the case of Mr. Senokwan, it was handled at a faster pace, Chair. And I'm not quite sure why are the reasons for other cases to be tracked like this. Chair, just want to add on what other members have been saying. And just to ask Ntatemo TV too, on the issue of lack of leadership within the Department of Water and Sanitation, do you think, in your own view, is this contributing to the maladministration or non-compliance or corruption and fraud which is happening in the department? I'm raising this thing because we had too many DGs who have been acting, who have been fired, who have been appointed by the department. Many DGs, more than 6 or more than 7 in that department. So do you think that lack of leadership in that department has contributed to this? And then the other matter, Chair, is on the Umgeni. Last week we saw the CEO for Umgeni has resigned with immediate effect. It was a shock to all of us, Chair, and one is wondering what was the reason for her resignation. I just want to check with Ntatemo TV and the team whether the CEO is also implicated in the SIU investigation. But lastly, Chair, Ntatemo TV, I think we also want to confirm as the portfolio committee with regard to most of your findings there, because as the portfolio committee, we went for an oversight around the areas of Giyani, of Limpopo. Majority of the people there don't have water. Even today, whereas money has been squandered. We visited also the water treatment around the area of Giyani, Vuwani. It's also not working and money has been squandered. People have benefited themselves with regard to taxpayers' money. So we want to support all these investigations, and where is needed, people must be able to be arrested, and government must be able to get money or recoup all the monies that has been spent irregularly. Chair. So I want to confirm that we visited some of the projects, and as we are speaking, they are also not working, and money has been spent recklessly. So thanks, Chair.
Thank you, Honorable Zeke. Honorable Sifai.
Thank you, Chairperson. Thank you very much. In appreciating the presentation by SIU, by Advocate Motibe, perhaps at the end of the process, the SIU has been exposed in a lot of criminal activities in the process. The advocate views at the end are not convincing. What are the real observations that SIU has in addressing this matter? This matter is a killer of our government and our society, and it's not taking us anywhere. And our people remain baboons. They have no services, they have nothing, and money is taken by individuals. And unfortunately, those individuals are people that have taking from have-nots. We would like to get the real. And also, I start from the back, I'm still going to speak, but the issue is your observation is not convincing in terms of what you see. Maybe you do that when you are reporting to your bosses of what must government do? Because it was said politicians are the most corrupt. And therefore, they should not participate in the Public Finance Management Act. And that tool is undermined like you cannot believe by officials. So I'm raising this to say, perhaps you needed to be part and parcel of changing some of the models that we've agreed upon as government with our excitement of being a democratic government. Your observations to me are not convincing. Maybe you'll present some at another level, or at maybe when you are reporting to your bosses. Chair, the issue of Umhlatuzi, the water board, an official in the entity who did not keep records for expenditure. Very serious offense. Because that person was said he has got skills. He's a professional. I'm not getting well on what has happened to that official. She has resigned during investigation, and therefore, where is the money? Where is the money? Because he's still alive. He's still alive. And our Financial Management Act is undermined like you cannot believe. Sunday's River, an amount of 7.9 million has been taken by the municipality. I don't understand, because that money is a money within the entity. What does the municipality do with that money? The municipality, not even a national government for water affairs, a municipality that has utilized that money for whatever she wants to use for. So want to get clarity, where is the relationship? The Misimda is not charged and the case is closed. Who is Misimda and why was not charged and the case is closed? Lepele entity, as you know, advocate, that this is an entity that was loud to the world about how bad the department is, how bad the minister is. It's amazing to hear these findings from such a caliber of person who had all the audacity to challenge the department, and knowing very well that he has got delegated functions from the department as an entity. But it's good that you have managed to find the truth in all what he has said in the public. I want us perhaps maybe UDM is still here. We need to challenge the powers and the authorities of the entities. Maybe we've given them so much, and therefore they think they represent the department. With a lot of money, they are taking decisions outside the department and utilize huge funds of money without the department. And on some of the activities, that should be departmental activities, not them, because they've got delegated powers. So I'm raising this now to the DM and the department, that perhaps we need to go back to the powers that we're giving the entities. There is no cooperation that we are getting here. And also very clear, there's been no oversight management by the department. I think the department is exposed. It's very, very much exposed on how it's not protecting the funds of our people. So exposed. Because one of the issues, Chair, is that department said they've got a strong monitoring and evaluation entity in the department. It's nowhere to be found. It does not exist. I mean, 2 millions are gone. Where was the department with its monitoring entity? Because the issue is what government does when it presents about monitoring and evaluation. It speaks about compliance. We're not speaking about compliance here. We want a watchdog that is able to see the funds when are misdirected. GM, I wish you are still here. An amount of 2.2 billion was to be set aside. Oh, akasalamba ngunozolile ohlala eAlwal North. Akanamanzi, akananto ngondithetha nabo.
I'm still here, Ma'am Nancy.
Ndiyavuya tata. Unozolile wase-Alwal North has nothing. She has got to go and get water. River. A 2.2 billion has been taken for something which is not by umdu who's able. This is painful, DM. Very, very painful. In a moment where our people fought for this liberation and now they are baboons. There's an interdict that has been given to Ulipele CEO. And you want to go to you see, once you take an audacity to clear yourself before you are investigated because you believe it is you, and at the end of the day, you are found guilty, not even guilty, a criminal. It's important that we know where is he. I hear that DM, the officials have procured some items within the entities themselves for the department. What's that? What are those? We don't want the items. We want to know what are those? What was their relationship in that? So that we know the caliber of the officials that we're dealing with. I have raised the issues which should have been now my closing initially. Please, SIU, help the government. Our revolution is suspended by individuals that we do not know who are they. And some we know. But the issue is, what are we doing? Thank you very much for Zondo Commission. I'm happy to hear that also you are working with that commission. That commission must do its work. It must do its work well. I appreciate what they are doing. Thank you very much, Chairperson.
Thank you very much, Ma'am Nancy. Do I still have any hands that is I've not recognized? I think all the hands have been recognized. Yes.
Mama Siswai, the hand is up.
Hayi,
No, but they've just spoken now.
Zithobe mntana. Zithobe
You
mntana.
forgot to
Sithobe sana lwami.
load the question. See, Ma'am Nancy, thank you very much. Thank you very much, Ma'am Nancy.
Thank you.
Yes, just to add on the question and the team and the team, just to, for me, it's on the disclosure forms. Disclosure forms, but the findings are not the same. What might be the problem? If I've not disclosed my involvement in the particular company, or I've not get the permission to do work outside government, and the other one did the same, is disclosure. All of us who have no disclosures, why the verdict are not the same? You have those that have been expelled, those that the case has been closed. What might be the issues, so that we can understand it better? The one reason that this committee decided to invite you, Advocate Mutivu, was on the Giyani matter. And one, it's very happy with the progress. And as Mr. K has indicated, Giyani has been, the people of Giyani have been suffering under the hands of the municipality itself and the department later through Lepelle Waterface. And one would just want to check, out of these cases, what I've seen, you've quoted Mopani municipality, because they were the first people who were given money to implement water in Giyani, and the money disappeared in the municipality before this intervention. So I just want to check the case. Does it extend to that part, or it's only for the recent one? Because I think the people of Giyani might want justice on the matter. Last thing is on the, and as I appreciate joining members to appreciate this good report, even motivating us that there is something that has been done, because at some point we felt that 4 years investigation, now it's a problem on its own. And if you have this department that everybody's been investigated, you therefore the issue of service delivery might suffer more, because the concentration will not be at work, it will be on the cases. Just to check on what do you think the portfolio committee, working with yourself to assist you to push these cases to the speed that is needed? What do you think should happen in our case as members of parliament, particularly with those issues that you think you have referred back them to the department? I was thinking that if you can actually, as you refer them, you notify the portfolio committee in future, other cases that might arise, we might be very helpful, because we would then ask the department as they come to report to us on the progress on those issues, So just to check that what can be the collaborative efforts between ourselves and yourself without tampering with your work. You're doing the good work,
just to identify areas where we can collaborate and make your work very easy and increase the pace in that regard. Thank you very much, Advocate Matiba, and your team. You can respond.
Advocate.
There's a hand,
Yes.
Chair.
So thank you, Honorable.
Sorry, Advocate. The hand from Honorable Zeki. Honorable Zeki, where were you? Because I couldn't see your hand.
Yes, I don't know what happened. I actually changed devices. Sorry, Chair. I was using my phone. Now I moved to the iPad without noticing that my hand has been up on the other device. My apology.
Okay,
Chair,
proceed.
Chairperson,
Sorry,
I don't know.
Sorry, Advocate Mutiba.
I don't normally celebrate when the fish swim because that's his job to swim. But I want to celebrate the work that is done by the DMT and the team because he doesn't only swim, but he swims better, according to the report that we just received. But Chair, we are a committee that does oversight. There was a committee before that was doing oversight. Equally, there was a department before that was doing the same. There are CEOs and managers, there are boards that does the same. Kentatem TV, I don't know whether in their findings they do what we call analysis. In their response, what made it so conducive for such wrongdoings to happen in our eyes? Because, Chair, when you listen, you just feel that it was just a free for all. Whereas the institutions that I'm talking about, they were there. Auditors were there. But things were happening in a wrong way. Can in their response maybe just say that? And then the other issue, Chair, is that what happens on death? My understanding is that a wrongdoer, when he has died, that case gets closed. A wrongdoer, when he has resigned, that case is not closed, except if it was a disciplinary hearing. But if it was a criminal case don't care whether you are in employment or you are not in employment. As long as you have done that criminal act, wherever you were, you will be followed. Maybe if the team can further explain that, because that's my understanding. Chair, those were my 2 points, and I would really want to ask to say, are we having tight cases here? Or we may fall on our swords. The celebration may not find its logical conclusion, but just die during the process in terms of tangible. Thank you, Chair.
Thank you, Honorable Zeki. Honorable Mutibi, Advocate Mutibi and your team.
Chairperson, can I come in? I've raised my hand. I'm worried you did not recognize me. My hand is up. If you can look at your gadget. Before they come in. Yes, Chairperson. Let me just start by saying that the parliamentary oversight has failed. Has failed this government.
That's another question.
That's why we are facing such corruption and maladministration in the country.
So I want to make a recommendation. My recommendation is that our portfolio committee needs to take the lead in reopening an inquiry into the Department of Water and Sanitation, as it appears as if corruption and maladministration is increasing in the department. So when we discuss this thing, let's also include this recommendation and agree on this recommendation so that we can stop corruption in the country. If we can take the lead, because the department is very corrupt of water and sanitation. So let's take the lead and try by all means to open inquiries. Thank you.
That recommendation, will put it for discussion later. Let's give Honorable Mutibi the platform to respond. Advocate Mutibi.
Oh, thank you, Honorable Chair. We appreciate the questions. I'll start off immediately with Honorable Mokgwato's questions. What advice can we give to the department to manage resources and risks? Honorable, what we also do as SIU is that we engage with the state institutions, department in this regard, to go through our investigation findings, and in particular where we show systemic issues, we would then engage with the department on what we call systemic recommendations. And systemic recommendations would be those recommendations that would point to improvement either in risk management processes, in the improvement of the control environment, or improvement generally in the planning environment. So what we do with the department, and perhaps there's now an opportunity to further engage so that we formalize the engagement with the department, where we go through line by line on systemic recommendations required and come out with action plans that could be incorporated in the department, either risk management processes or planning processes. And there should be adequate monitoring of those action plans. So we will reach out to the department, as we have done with other departments, to engage on this aspect. The challenges that we have experienced, it's another question. We have pointed out in various slides, for example, in the Lepelle, and this has come up in other questions. In the Lepelle Northern Water, my observation is actually that that's where the pushback was more pronounced from the CEO, the then CEO, and the then board. As we have mentioned in our presentation, Honorable Chair and Honorable Members, we were faced with a situation where even with the authorized investigation of SIU, the CEO and the board appointed a private company that would then seem to stand between SIU and the Lepelle Northern Water Board. That we found as a clear intention to disrupt and interfere with the SIU investigation. And we didn't end there. We raised these issues with the then board, and we also raised it with the ministry at the time. And I recall that the CEO at the time was called in. We met with the minister at the time where these matters were discussed, and the CEO undertook that he would cooperate with SIU. But contrary to that undertaking, we saw the lack of cooperation continuing, and that has necessitated, as we have presented, that in some instances we realize that if we don't use the powers that SIU have, and these are the powers that we really don't easily use, particularly that we are dealing with state institutions which are ordinarily expected to cooperate. We had to even resort to these powers of search and seizure. And once we undertook those powers, the evidence that we gathered even revealed further irregularities and further maladministration. So we did refer the CEO for disciplinary process. We also referred the board for action to be taken against them. Well, as we sit today, the former board has now been disestablished. We have since also interacted with the new board, and the new board, we presented a similar presentation to them. Well, of course, we carved out only the Lepelle part and presented to them. They have undertaken that they will cooperate with us in further investigations. The CEO has since resigned, and the question also was raised, where is the CEO? And as far as we were informed, he resigned. And that is why we sought to take that step that would ensure that some accountability is meted out on him. And we then proceeded in the special tribunal where we got an interdict for the payment of his pension. So as we speak today, the legal process is underway to ensure that ultimately the recovery is meted out from him and all those who are mentioned in the court papers. So the fact that he has resigned will not make him free of any processes, particularly if there's any criminal actions against him or civil litigation against him. He will not be absolved of that. The issue relating to the construction industry, should there not be a broader proclamation or investigation? I seem to agree with that view. And this is similar to an engagement that we have had with the Ministry of Public Works. And we are in engagement to ensuring that this area of infrastructure receives a wider attention from an anti-corruption perspective. So we will continue with those engagements and all the stakeholders, and we are glad that the honorable committee or honorable member has presented that question. So we will have ultimately a framework, which is an anti-corruption framework in the infrastructure, and we will ensure that all the stakeholders are informed. This, we will use the model that we have implemented in the health sector space. We do have a model that we can learn from, where we have ensured that the health sector receives a comprehensive approach from an anti-corruption perspective. And we have included even the civil society to ensure that all the allegations that are presented are investigated appropriately. But also of importance is that we would then also do the prevention part of anti-corruption. So it's going to be a holistic approach that we take. And that may probably also result in a wider proclamation to deal with that. But that will be assessed as we put together this infrastructure anti-corruption framework and forum. Honorable Makwezi, on the issue of dismissed staff, what happens to the criminal case? Does it continue? The answer is yes. If an employee resigns, the only relationship that the employee ends by resignation, he or she is ending the employer-employee relationship by law. But the other consequences relating to criminal prosecution, the resignation does not end those. The resignation does not also end the civil litigation process to recover against that specific official. What happens to people who resign? As I indicated, that this phenomenon of people resigning and joining government in other departments, we have observed that as much as the Honorable Committee has observed, and we are ensuring that, as we indicated in one slide, there's a provision in the Public Service Act. Although that is in the Public Service Act, and this phenomena presents itself in the wider public sector, like in the SOEs, in the municipalities, and so on, we are ensuring that this approach is also implemented at all spheres of government. There's a question on how do we receive allegations. The allegations are received from various sources. Others are received from state institutions themselves, state departments, but a large percentage of allegations are received from whistleblowers. We do have a whistleblower platform, and I've requested my colleague, Mr. Kaiser Khanyago, to also comment on this, because they are quite vocal when they interact with the public, that the public has a platform on which they can report. With your permission, Honorable Chair, just a few minutes, Mr. Lekgetho can just indicate on how do we receive the allegations.
Thank you very much, HOU, and thank you very much to the Honorable Chair and members. We have got a 24-hour whistleblowing hotline, and the hotline number that we use is 0800 037 774. 0800 037 774. We also have email addresses that we use. The one email is siu@whistleblowing.co.za, and the other one is info@siu.org.za. Those are the platforms that we are using to make sure that the people can reach us and be able to contact us, and they are operational on a 24-hour basis. And we urge the public to use those numbers and email addresses, because we will then take them into the system once they are sent that way. Thank you very much, HOU.
Thank you, Mr. Khanyago. So once the allegations are reported on the platform, there is then a governance process in SIU to assess those allegations and make sure that they meet the standards as expected by the legislation, and then we take them through the proclamation process. Until the proclamation is signed off, then the formal investigation kicks off. Are there any cases where SIU referred to NPA and has not been prosecuted? Yes, there are cases where prosecution has not been effected as yet. But in some of the slides, as we indicated, there are dedicated prosecutors that have now been allocated. We have observed this issue back in 2017, I would say, when we adopted our new strategy. Our new strategy, amongst others, indicated to us that if SIU does not follow on the referrals, then SIU will not make the impact that it requires to make. One of those referrals is referrals to NPA, referrals to the accounting officers to take disciplinary action, and also referrals for civil litigation. Except that the civil litigation is the only one where SIU has got control end to end. We start the civil litigation until we take it to court and special tribunal currently, and we handle that to completion. The others, as one of the honorable members indicated, we then hand over to other state institutions like NPA. But we do have the framework now with the NPA, and we are glad to see that there's action been taken to ensure that those cases are prosecuted. Of course, when we pick up that there's criminal action committed, evidence relating to that, we take that evidence and we hand it over to the NPA. The NPA still has the duty in terms of their responsibilities to assess it and ensure that is the evidence that would ensure successful prosecution. The issue around Umhlathuze water, 2008 proclamation, and little has been done in case of prosecution. I think those were some of the matters that we raised with the National Prosecuting Authority to ensure that there's actions taken. So our view is that we should, at the end of all of these follow-ups, be able to respond with regards to those matters. We do have, as I said, a memorandum of understanding with the NPA, which we are currently improving, because we've realized that we needed to bring in the Hawks as one member in the memorandum of understanding and the SAPS, so that we deal with these matters holistically. The issue around the Lepel Northern Water, the question was, we got the impression that the CEO took the minister on. Yeah, I think I responded when I mentioned the challenges. He actually, in our view, the CEO was almost taking on this SIU and seeking to interfere with our investigation. But we really managed to ensure that that is addressed, and also that the disciplinary steps are taken. The board, yes, and this is the current board. The current board has now withdrawn from the civil litigation that was instituted by the former board. So as we speak today, it's only Mr. Lehodi who is now seeking to be still involved in the civil litigation. But we are steadfast in saying we will defend that case. We are of the view that he's got no case. Of course, it will be adjudicated at court. To date, my colleague, Dr. Wells, who is also in the meeting, is our chief legal counsel, is monitoring all these cases to ensure that the SARS, the SIU cases are taken to their logical conclusion, and the interest of government in general, of SIU and of the department are protected. The issue around mentioning of names, The principle that we adopt in the names being mentioned, if there has been a referral of disciplinary hearing and the actions have been taken, then we are of the view that the legal risk is minimal and that we are able to mention the names. Where there has been criminal referrals, the principle that we are taking generally as law enforcement agencies and generally in law is that where the person has not been charged yet, then we cannot mention the name without going facing the risk of a legal risk. So, and then where there is a civil litigation, similarly, before the summonses are issued, and when the summonses are issued, it becomes public, then we are able to mention those names without being confronted with a legal risk. So honorable members, this is the approach that we take. The names that we have mentioned, you'd find that in many instances is areas where there has been civil litigation taken, disciplinary processes taken, and probably instances where criminal cases have been brought, and where they have been charged, then we are able to mention the names. There was a question around what does kickback mean? If you look at, I think it's slide 63, where we mentioned that the allegations that we received, one of the allegations was that the officials received 35 million kickback. And this is the language that's really used in many instances, but it really, in our assessment, it really means that it could fit within the definition of bribery. And it could also fit within the definition of corruption. So it effectively means that the officials received, well, this is the allegation meant that officials received 35 million, which they were not authorized to receive, and they received it on a corrupt basis, fraudulently or as bribery. And all of those result in criminal charges. As my colleague indicated, the investigation has not yet been closed. We have returned a finding there that the procurement process was irregular, and that is why we are in the special tribunal already seeking to recover the monies that the department has paid. We will also point to those officials who were involved. I think one honorable member indicated that wherever there's irregularities, there is bound to be a process internally where even officials authorize some of the steps. So we are seeking to uncover by following the processes in terms of who participated in these irregularities. The issue around OCAMP, I'm gonna ask my colleague Gina if you can just look into this OCAMP question. How is it that it was paid, and what is it that we are likely to do? So with your permission, Honorable Chair, I'll move on. My colleague will later on address that part. The issue of water leaks, I think we have mentioned now that we are considering that, given the reports that we have received. And once we have done that, we will then issue or process a proclamation to investigate that area. Honorable Moshala, what is the basis for department closing matters when there's no evidence? I think we have raised it in our presentation that we have approached the department in those matters where the cases have been closed, because we believe that without coming to SIU, we believe that we had evidence that necessitated that referral and that could assist the department in instituting the disciplinary process against those officials. The issue around why is SIU taking long to complete the investigation? Honorable members, this we have taken to heart that comment. In fact, our new strategy clearly indicates that we should not have an investigation that takes more than a year. And the decision that we have taken, I think we took this decision almost a while back, 2 or so years ago, that where an investigation takes more than a year, we need to produce an interim report. Because the investigations differ depending on the complexity of the investigations. However, as I indicated before, honorable members, is that even during the investigation, before we even reach the reporting stage, if we start off with the investigation and make a finding of irregularity, for example, say within 3 months or within 6 months, then that finding is actioned immediately. If there's an irregularity finding, the contract has been irregular, we then start off immediately. We don't wait for the report to institute any action, whether it's civil, discipline, or criminal. But we are really seeking to improve, and we have seen that improvement. The example to demonstrate that it's, and I will mention it as an example, honorable members, is the investigation that we are faced with now, the COVID-19 investigations. We have ensured that we live up to the undertaking that we have made, that we need to improve the turnaround times of the investigations. And we continue to ensure that even with other investigations, be it in other departments, state-owned entities, we have to improve on our turnaround times of our investigations. Because we have realized that the longer the investigation take, is the risk that the documents will disappear, the evidence will dissipate, and we may not make the impact that's required. So in this case, we really need to assure the Honorable Committee that we are taking steps to ensure that the turnaround times are improved. In the sub-matter already, the findings have been made. We are already in court, and we have indicated that a report ultimately will be produced. The issue around insufficient funding, indeed, honorable member, we have been on record as saying, given the increase of the proclamations that we are seeing, if we don't increase or deal with the funding model of SIU, we are likely to see the investigations being hampered. So we have since engaged the National Treasury. We are busy now with our SIU amendment. In that amendment, we would like to address the issue of the funding model, in which case it would be a sustainable model so that we don't depend on charging the departments for our services, because we have seen that if we charge the departments, most of them, a good percentage, they do not pay, citing insufficient funds. In other instances, they would say they did not budget for the investigations. So we are reviewing the funding model, but in between, even before the amendment, we have made our presentation to the National Treasury that the additional funding be granted to SIU, and other law enforcement agencies. So we are hopeful that even before then, that additional funding would be provided. But as we speak currently, we are able to employ with the funding that we have. We've advertised recently for 25 positions around forensic accountants, forensic legal, the ones that we need immediately to ensure that some of these critical investigations are done. How much does one proclamation cost? The cost of investigations are driven by the resources that we employ, and this is the letter of engagement that we have with the department would ultimately indicate the overall cost of the investigation. At the moment, I do not have the exact cost, but we can look into the current letter of engagement that we have with the department. My colleague Gina, if you've got the information readily, you can inform the Honorable Committee. Otherwise, we will present that response to the committee in terms of the cost of the investigation. We can respond to the committee in writing on this aspect. We do have the letter of engagement, and the letter of engagement does have the overall cost in it. We just don't have it readily at the moment. Is the SIU liaising with the NPA? I've covered that point. We do liaise with the NPA on an ongoing basis to ensure that they prosecute on our matters. When people resign, what is the SIU doing? I think I did mention that we do not just end there. When a person resigns, we follow up on criminal and civil litigation to ensure that we continuously hold them to account. Senogwani is the only one that has been charged. Oh yeah, in this instance, the investigation will also reveal which officials were involved in the irregularities. And I think we have also indicated that there is a civil litigation that's ongoing to recover the losses the department suffered. There is there's disciplinary processes that have been referred, because the honorable member is correct that there would be officials that are authorizing these processes. So it cannot be that it's only the the service provider who's confronted. We also make sure that the officials are confronted. What is the view on the department having an internal forensic department? It is standard practice in all the state institutions that they would have internal investigation capacity. So our view is that we would support that. However, if there is an opportunity for SIU to come in and assist the department, the department would then refer some of the matters to SIU. But we have observed in various departments that they do have internal investigating capacity, which deals with immediate requirements for investigations by the department. So it's not an anomaly to have an internal forensic department. I think it's Honorable Zeki that indicated that the SIU should pursue all the referrals. Indeed, we agree, and it is at the moment our strategy. When we revised our strategy almost 3 years ago, we did realize that failure to follow up on these referrals would not result in appropriate consequence management, and we will not make the impact that we require. So as part of our value chain, our business process, we have created a function in SIU that is charged with the pre-proclamation functions to ensure that the allegations are assessed properly and put together the proclamation. But that department is also charged with the function of ensuring that once the investigation is completed, they also have a mechanism and a framework to make sure that they follow up. We have, through that department, we have also engaged with the presidency to ensure that all the reports that have been issued to the president are released to the state institutions. So by releasing those reports, we are ensuring that the accounting officers and accounting and executive authorities are aware of those reports, and they follow up and ensure that SIU referrals are acted upon. Comprehensive, Honorable Theki, I agree that I'm sure it would really be helpful for the committee to get a comprehensive report from the department relating to some of the referrals we have made. Is it possible for government to name and shame? We really support that approach. And an example of that is that if there's a service provider against which there's a finding made, that there is a process, and it's an administrative process to blacklist the service provider. So I think there's an opportunity to ensure that those who are guilty of corruption, they should also be named. So on this one, we'll probably have to engage with the other stakeholders and possibly present it at the JCPS to ensure that it's considered. We would undertake to prepare that process, and we can report back to the committee in terms of how it's going. We can engage with the public administration, public service and administration to take that thought forward and then report back. SIU dragging some of the investigations. I think I've covered it when I responded to the point that SIU takes long. We really want to make sure that there is not at all, any impression anymore that the investigations are being delayed, or at least from our side. From our side, we want to eliminate any delays. If the delays are caused by the state institutions or departments, we would like to make sure that we surface them and escalate to the accounting officer or escalate to the executive authority, as the case may be, so that those delays are dealt with and dealt with speedily. There's a question around whether the lack of leadership within the department has contributed to maladministration. Our observation is yes. And this is the case for any governance process or any institution. Where there is no leadership stability, that is likely to reflect in the operations of the organization. So it is our view that that has actually been a contributing factor to the irregularities that may have festered. Now, a related question is, how come that all these irregularities could be done when there was management? Honorable members, it is an observation that we have made, not only in this department, but in various of the state institutions, that failure failure to take actions, failure to institute, for example, SIU recommendations, or just failure to take actions when there's wrongdoing in the departments, it does create the culture of impunity. Well, in many instances, we have uncovered cases of collusion. We've uncovered cases of corruption. And where there's collusion, it really becomes an issue. But where it is detected, it is really incumbent on the leadership to take action, and failure to do so results in this act of corruption festering and continuing. So we are of the view that consequence management is what must be demonstrated, that there are consequences for wrongdoing. Umgeni CEO, yes, we are aware that the CEO has resigned. And at that time, I got report from our team in KZN because we have taken an approach that says if the CEO resign, like we did in the Lepelle part, that we need to ensure that the CEO is not implicated. And if he is implicated, we need to take actions that we do preserve the measures that can ensure that we recover. I've been informed by the team that the CEO who resigned is not implicated. These matters happened during the former CEO before this one who resigned. And that one and the board that was in place at the time is going to be held responsible and to account, and we are busy with that action. The areas around Giyani, I cannot agree with you more, Honorable Member. It is our observation as well that the community of Giyani is still denied of a service of clean water, and that is a serious issue that we have pointed out that requires attention. But of course, we are of the view that all of what we have observed and pronounced ourselves on as irregularities and shortcomings in terms of project management, procurement processes, those issues have to be attended to so that going forward, there is no repeat of these scenarios. The issue around what are the real, Honorable Siswai, what are the real observations? Of course, we have made a detailed report in this regard to when we submit the overall report to the President. My assumptions as I speak now is that that report would have been, as part of releasing all the reports, that report should now be with the accounting officer or the accounting authority. I'm sure the report could also be released to this honorable committee. But the observations that I've made when I made my closing of the presentation is that, and I still say, there's observations of serious maladministration, observations of serious malpractices, observations of corruption, and conflicts of interest. Of course, we need to ensure that when there are those observations, it's who then do we hold accountable for that? And we believe we have pointed out where there's credible evidence that points to a specific official or service providers. We believe we have pointed out in the reports and all the referrals that we have made to ensure that actions are taken. So it is our view that there is a clear need to take into account the observations to increase on the process management, risk management, and some of the business processes in the department to ensure that there's no repeat of this maladministration. And as I've said, we will be reaching out to the department to ensure that we engage around systemic improvements. The observations are not in detail. Yes, as I said, we've detailed the observations in the final report. In fact, we issued an interim report. So that report, it's my view that the department, by now they should be having it. If not, the department should reach out to presidency so that that report can be handed over, and that should then, give the opportunity to study it in detail, and of course, as we engage with the department, to ensure that we correct the wrongdoing. The issue around Sunday's River, why did the money end up with the municipality? The process there, and I think we did indicate that it was some agreement that was reached after the intervention of SIU. Again, I do not have all the facts at the moment in terms of why did the money end up with the municipality and not the department or the entity. We can revert to the Honorable Committee on that to ensure that that information is provided. The issue around the Lepelle Northern Water, I've taken that into account, Honorable Sifai, that yes, the Lepelle Northern Water, that is, as I said before, that is really where the challenges against our investigations were more pronounced. And really we were of the view that those challenges are malicious and they needed to be stopped. And hence, we made the referrals that we did. The issue around the powers of the entities, I'm sure that's the matter that the department and the committee can review going forward. The issue around no cooperation from Lepelle Northern Water, Honorable Chair and Honorable Members, I think I've dealt with that. No oversight by the department. Our investigations has thoroughly revealed that there has been a failure of oversight, and that part requires an improvement so that the department is not exposed going forward. Why was the department where was the department with its monitoring and evaluation? I think is the point that I've covered. The interdict against the Lepelle Northern Water CEO is the interdict against his pension, so that when he resigned, we made sure that he's not paid out, just so that that becomes one of the messages that we send out there, that officials and CEOs cannot commit irregularities and end up resigning and think that nothing will happen to them. So this is one of the measures that we put in place over and above the criminal processes, the civil litigation processes. So the interdict, we have since obtained it. He has not received his pension up to now. Yes, we are prepared, Honorable Sifai, to help government fight corruption, improve processes in state institutions, and hence our systemic improvements recommendations to the departments. Honorable Chair, the disclosure forms and the question around the differences of verdicts, that has also worried us, but we have not ended there. We've engaged the departments because we see that in some instances, the verdict or the sanction is written warning, and in some instances there's some differences. So, and the charge is the same, is the conflict of interest, either doing business with the state, or in some instances failure to declare. So in these instances, as we indicated, these are the processes in the realm of the department. The accounting officer is charged to ensure that there's action been taken and the appropriate verdicts are given. But we also observed that there has been those differences in verdicts, and we will of course engage the department in that regard. The Guyani matter, I've commented on that. That was part of the findings that we have made, and we would like to ensure that the irregularities are not repeated, and the referrals that we have made are acted upon. Honorable Chair, you've mentioned the issue around Mopani municipality. On this one, I know that the proclamation that was dealing with the Lepelle and the others did not cover Mopani. And my colleague, Mr. Lekgeto, who's the Chief National Investigating Officer, can give us or give the Honorable Committee an update on that one. It was covered by a different proclamation, which is currently underway being investigated. Mr. Lekgeto, with your permission, Honorable Chair, Mr. Lekgeto can update the committee for a few minutes in terms of that Mopani proclamation. Mr. Lekgeto, over to you.
Thank you, Advocate, and thank you, Honorable Chairperson and Honorable Member. I can indicate that in terms of the Mopani, we received a proclamation of which the first one was issued in 2017, and there was amendment which was made to that particular proclamation on 2018 and 2019. And that proclamation looked at a whole range of other issues, but with regard to water, it's specifically looking at the procurement of new boreholes and also repair and maintenance of already existing boreholes. So in terms of this investigation, we are done with the investigation. Currently, the team is wrapping up. We have already made criminal referrals. We have already made disciplinary referrals to the municipality with regard to this investigation. So we can clearly confirm that the investigation is finalized, where some of the findings that some of the boreholes were not constructed as per the requirements, and money was paid to the service provider. So we are done on this investigation. And also, Advocate, I can also answer on the issue of ICOM. The issue was why were the service provider removing the item from the site. We indicated that the item were removed by the subcontractors from the site because the subcontractor had a dispute with the service provider, which is ICOM. As a result, they were not paid, and they went to the sites to go and remove some of the item, and of which we say some of those items are going to be replaced by the department, and that's going to create more expenditure to the department. But currently, we are waiting for the departments to go and engineer to go and do some assessment that they can able to give us so that we can able to quantify how much has been they've removed and how much is left. And we also indicated that the service provider has been paid 72% of the total contract, whereas the whole contract has not yet run its course. So that is our that is our observation that we have done so far. That's all I can indicate. And on the issue of how much does a SIU investigation cost, the example we can give is the SAP investigation, of which the cost that we have seen in terms of the letter of engagement it costs about 4.8 million. And this is based on the 11 resources that has been allocated to the investigation. And this is just an estimate based on the period that the investigation will take. You find that in most cases, the cost is much lesser. The ballpark that we give to the department is so that they can able to do the budgeting in terms of the investigation. So this one average is 4.8, but in most cases, it depends on what is it that we're investigating. Some of the proclamation are multifaceted and they include a whole lot of other things, whereby they take long and they deal with many issues. In that instances, the cost will go higher. And because we're gonna have to be required to allocate more resources. So more or less, this is how it is. But you find that in some instances, the costs go much lower. So it just depends on what is it that we're investigating and how complex it is that we will have to finalize that investigation and the time period. Thank you, Advocate.
Thank you, Mr. Alfeto. Thank you, Honorable Chair and Honorable Members. Honorable Chair, I'd like to just also respond to the question you raised around the collaborative efforts between SIU and the department and also with the Honorable Committee. We have the view that there's an opportunity where from time to time, SIU can do what we are doing today, briefing the committee on the status of our investigations. We can also collaborate with the department in terms of those systemic recommendations and systemic improvements. And we can also ensure that where there's areas of improvement, we implement that. So there is an opportunity for collaboration where the Honorable Committee can also continuously exercise an oversight on matters that are the plan that's put in place to improve, the steps that are implemented, and whether that plan is being implemented or not. Honorable Member Zeki, we really welcome the kind words that the fish is normally not praised for swimming. We welcome the words of encouragement, and it is our view that we must continue on that trajectory to make sure that we do our work and do it with the integrity that it deserves, bring out the legal outcomes, hold those who are responsible to account, and speedily. I think the point that came up today as well is we need to improve, continue to improve on the turnaround times of our investigations. Does SIU do analysis? Yes, we do analysis of all the, in operational risk terms, we look at people, process, systems, and all of the other improvements that are required. People improvement in terms of the involvement of officials in all of these irregularities, process failures that we may have picked up, and then we do then those systemic recommendations. And if there have been any systems failures, we then also do that analysis and approach the department with systemic recommendation. What makes it so conducive for things to go wrong? I think I've addressed that. Just the culture of non-monitoring, not taking action, that breeds a culture of impunity. And when that culture of impunity sets in, we are bound to see all these kind of irregularities. And of course, we need to deal with those who are responsible. Where collusion is detected, we need to deal with it immediately so that a message can be sent out. There is a term called deterrent. We need to ensure that we deter those would-be corrupt people that are still sort of planning to do because they had realized that actions are not being taken. What happens on the death? My experience in criminal law terms, the death does bring a criminal case related to the deceased to an end. But in terms of civil litigation, there are processes that will not end relating to, call it, estate of the deceased and so on. So that's my response to that. That we will not just sit back simply because the person that we were pursuing is deceased. We'll have to still continue to explore the legal avenues to recover. Are we having tight cases here? Our view is that, and as I said before, relating to criminal matters, we do hand over the criminal evidence to the NPA, and at that score, the NPA does go through the evidence. If there's a need for further investigation, they do interact with the Hawks to ensure that, you know, wherever they can assist, they assist. But we are of the view that where there's a need for further investigation, that part needs to be referred back to SIU, not to Hawks, because they are going to start afresh and it delays the whole process. And hence the memorandum of understanding is going to now include SIU, NPA, Hawks, and SAPS. So we believe that when we hand over the evidence, it does prima facie indicate a criminal act, but the NPA still has the duty to go through it and then return a decision to prosecute. We have noted the last comment by Honorable Mushala around the need or otherwise of the inquiry by the committee. That's obviously in the purview of the committee. In any way that we can assist, SIU remains available to assist the committee in exercising its oversight duties. Honorable Chair, thank you very much for the opportunity to respond. I will pause here. Thanks.
Thank you very much, Advocate Mutivi and your team. Indeed, your report, it has empowered us as members of Parliament, and we want to acknowledge the progress report that you have presented to us, and we want to wish you well in your execution of your task. It's not an easy task. You have our support as members of Parliament. And honorable members, as we release them, because now it's 1 o'clock, and we want to welcome again the interaction that it will continue. We'll have the continuation of engagement with yourselves as we proceed in this term, and we want to welcome that. And let me check if there is any member who think the question has not been answered before we release Advocate and his team. Are we fine, honorable members? Honorable members?
Yes, you are fine, Chair. We are fine, Chair. But
Okay, thank you very much.
Chairperson.
Yes.
We are fine, but I think
yes,
the issue that has raised that there is a more comprehensive report with a recommendation that he has made in terms of his observation. Perhaps you will help us that at another time we need to be exposed on that, because we think that is very relevant for us to be empowered on the findings that they've made. Those observations and recommendations that are comprehensive. Thank you, Chair.
Thank you very much, Honorable the report is with the president, as they've indicated, and the president will then give it to, probably they'll put it on their website and give it to department for further implementation. So we can actually get the report for members to look at that immediately the president publicize it, because they report to the president. Thank you very much, Advocate Mutibi and your team. You can be released. Advocate.
Bye.
Thank you, Honorable Chair. Thank you, Honorable members.
And
Thank
the department were released, Chair. Ne?
Oh, thank you, DM.
No, DM.
Okay,
Thank you.
Comrade
Thank you.
Mutibu, you are the
Thank you,
only ones
Captain Tibu.
fortunate.
All the best.
Thank you, DM.
Thank you very much. Honorable members, there was a proposal by Honorable Mohlala that as a committee we should look at the to constitute the inquiry. Can I get members to talk to the recommendation, to the proposal?
Chair.
Honorable
Chairperson.
Sifai, raise your hand on the system so that I can see.
Okay. Here's a hand.
Okay, thank you very much. Other members? Honorable Zeki, Honorable Saike,
Honorable Mvana.
Honorable Mvana, Honorable Mvana, and then other names, because when we finish, because I don't want people to listen to other people and then wants to come back. Can all of us that want to speak raise hands?
Let's move, Chair. It's late.
Yes, I know it's late, honorable members. It's Honorable Sifai, Honorable Zeke, Honorable Zeki, Honorable Mvana. Can we follow like that? Honorable Sifai, you're the first.
Thank you, Chairperson. I think the proposal by a member, honorable member, has got a huge wisdom, so that we all understand the nature of the problems that we are confronted with. But because of the legalities of that issues, I thought perhaps not something that we're going to respond to it now. We will take that as a proposal in the meeting. Then we first interrogate the legalities of such. Then we come back with a report. That is my proposal, Chairperson. Thank you very much.
Honorable Zeke.
Chair, thanks very much. The member started by saying the parliamentary oversight has failed. And I want to upfront to say this was a previous committee in the 5th Parliament. So we are a new committee in the 6th Parliament. We've got matters before us that were supposed to deal with us. We acknowledge the corruptions and the fraud cases that are there before the department and us, and it's our responsibility as the new portfolio committee in the new administration to conduct our vigorous oversight in the department. So I therefore feel, Chair, that the what is that she's recommending? The inquiry. The inquiry for now, which is not possible. We've got powers, we've got the responsibility as the portfolio committee led by you, Chair, to deal with the matters before us. So, Chair, that's my proposal. I don't support the issue of the inquiry. And in addition, Chair, the SIU is doing its work, and let's support all the law enforcement agencies, SIU, NPA, and let's follow up all the referrals referred to the department. I think that is our key responsibility. Thank you very much.
Honorable Zeki.
Yeah, I'm covered. Member Mhlala's proposal is a duplication of the current state of investigations. So we can't form an investigation on top of an investigation. Thank you.
Thank you very much, Honorable Mvana.
Thank you, Chair. I'm sorry, Chair, I'm not well. I haven't apologized for that. But what I was also going to say, maybe we'll say the same song. Well, there is no need for inquiry or commission of inquiry because the investigation has been already undertaken. Let's rather deal with what is in front of us, because even if you deal with this inquiry, it's a lot of money that we have to spend, whilst it is really a fifth administration. So now I'm also not for the inquiry or commission of inquiry. Let's ask the department and also the SIU and everybody to deal with whatever that is in front of them. If they need to expel, they must dismiss and expel those that are found guilty. If they have to recommend that they must monies, the government money must be returned back. Thanks, Chair.
Thank you very much, Honorable Mvana. Please recover soon. We need you. Honorable Mashiko.
No, where is me? Thanks,
Namela Taba, man. Namela Taba.
Oh, okay. Maybe we can move in the mountain. Can you hear me now?
Yes.
Okay. No, I was saying, Chad, look, while the SIU is investigating was on the basis of us having taken the decision in 2019 when we were starting this particular work as the new committee. And in that committee, in that this discussion, we're saying we think that there is a need for somebody to investigate these wrongs, war on leaks and all other things. And so SIU is doing exactly that point. So in supporting the views that says that we do not need another investigation because SIU is on our behalf investigating as us by us. It's not about us just opposing Member Mhlala. It was on the basis of the fact that this report that we're getting is from our own call that SIU must investigate and give us. They've got good investigative way. We cannot investigate ourselves as a committee or as parliament. SIU is better place to do that. It's not just a refusal or just an opposition by the way of it being said by another member. And I don't believe that we really need to duplicate our work in that particular sense. Thanks, Chair.
Thank you very much, Honorable Mhlala.
Chairperson, thanks so much. I think these people, the honorable members, are just changing what I've said. They are not saying exactly what I said. I've never ever said we must now do the work of the SIU. The SIU is doing its own work. We have the constitutional mandate. The SIU has the constitutional mandate. As a committee, We have our own constitutional mandate. We must lead in terms of our parliamentary oversight. The process by SIU and parliamentary oversight is two different things. We must hold the executive into account. SIU and department can't do this on our behalf. There is corruption. Mr. Motibe have said that. He said the maladministration in Department of Human Settlement, the water and sanitation is going, is progressing, is happening. So we are saying, let's run, investigate on our, the SIU cannot investigate on our behalf. Let's do the investigations ourselves as a committee. I've never said that we must now stop the SIU for doing the work. The SIU must still proceed and do the work, but this corruption in this portfolio committee is happening. So let's do our own investigation ourselves. If Honorable Mhlala is stealing from the poor, the committee must hold Honorable Mhlala accountable. Anything that is happening in our committee, it cannot happen under our watch, waiting for the SIU. The SIU must be helped by us as a committee because we have two different constitutional mandates. They are doing their own, we must do our own. Thank you.
Thank you, Honorable Member. Honorable members have indicated that there is no need for commission of inquiry for now. And I agree that we must do the oversight as we do it. For the fact that we are calling SIU to come and give us a progress report in terms of their investigation. Now we know that there are cases that they've referred to the department which are not fast-tracked. So we'll then call the department to come and account on the issues as Comrade Tseke has proposed. So members, they are indicating that there is no need for the commission of inquiry as proposed, because the commission of inquiry on its own needs finances, needs capabilities, needs all the investigative issues. And I want to talk to the issue that Ma'am Setlhai has talked about of the commission of inquiry that has been established. Zondo Commission is established for anybody who has got any other thing that does not surface now to go there and give it to the commission. And all of us, we are welcome as members or individuals to go and present all those issues to the commission of inquiry. Ourselves will continue to do our oversight, calling the department to account. So there is no need for other inquiry, honorable members. So can we proceed on that note?
Yes, Chair, agreed.
Agreed, Chair.
Thank you, honorable members. I promise that we should come back to that issue, and I want to thank members that we have allowed us to proceed with this important meeting before we can actually deal with our matter. On the issue of requesting the time to be changed, and I did it at 1816. I called the administrator to say I saw there is the change of movement of the bus, which is going to move at 8:30, means that we are going to arrive at 9:30 in Parliament. So I therefore request, yes, Honorable Mashego. Honorable Mashego.
Just leave the meeting, Chair.
Yeah.
Remember we said when they presented, they can leave and speak to our matters. Are they still in the meeting now? Dr. Motibe and his team?
They've left, I think.
Let them leave first, Chair.
Okay. Can we ask our guests to leave our meeting?
And departmental officials?
Yes, and the departmental officials, can you go and PMG, can you leave our meeting, please?
Tabise.
Kamela Mantashi, can you leave?
Acting DG.
Have been changed. I requested that the administrator to communicate with members. And as we were discussing, Mr. Ngwezi said they've not been, there was that communication. And I want to apologize, honorable members, that the communication could not reach you, and we end up discussing the way we've been discussing. And I want to put I want to apologize for that, because it was not my decision just to decide what time I'll leave my home. I know that the bus was going to leave at 8, and suddenly the change of time was informed of change of time. So I would ask, I would go to the relevant offices to inquire about it. So if all of us, we have to go to our homes so that we can have a visual meeting at our homes, so that we can do that. So, so I'll inquire about it, why the buses have been changed, and without actually even notifying members that there would have been a change. Because if I knew that there was been a change, I could have made my own arrangement to arrive on time. So I want to apologize, honorable members. There was never any reason to undermine the committee, or to any motive besides that. That was the issue that I was confronted with. So that is, yes, Honorable Mashala.
Okay. No, thanks so much, Chairperson. We do acknowledge that you are saying that you're still going to get exactly what is happening in terms of the rules of Parliament with regards to delays in meetings. Chairperson, but I think you need to leave the issue of transport. Transport is not an issue here, and it must never be an issue. The issue,
it is, ma'am.
yeah, Yeah, you must leave it. Don't mention it in the meeting, because yes, we understand it was not your problem for you to be in the meeting. It was not your problem for you not to be in the meeting in time, but you should have allowed Parliament rules to take part. But I'm happy because I'm hearing you saying that you're still going to find out. You did not know actually what you must do. And you did not even allow yourself time to
Honorable member,
listen,
you are
but
twisting
you
my
must not do
words.
that. You are always interjecting me when I talk. You
No,
don't
but you
allow
are twisting my words.
and
I've
at the
never
end
said
of
those
it, but you
things.
must listen and then come back and say I'm not speaking what you said.
Okay.
Yes.
Continue. Continue,
Because every now
member.
and then
Continue.
come and
My
interject.
apology. Continue, member. Continue.
So mina ngendlela engikuzwe ngayo uthi wena you still going to check with Parliament. And earlier it seems like you even said your order is the order is not my order is not sustained and all those things. You should have said I don't know. I will go and inquire from now onwards. We will do things differently or as per the rules of Parliament. Thank you, Chair. Thanks.
Thank you, Honorable Masala. Honorable Masala, I've never said I didn't. I've never said I didn't know. What I did was to request the secretary of the committee to notify members of the problem that of the bus and members of the committee, and request that the meeting should start at 9:30. So if the member and Honorable Ngwedzi has responded to say that they've not received the notification, and I phoned it on 8:16 at that time. So I've never said I didn't know the rules. I know the rules. That's why I've requested members that we should start at 9:30. And if members were rejecting, because you were in the meeting, you had that power to reject and say you proceed without me. And later on, I could have we're going to handle it differently. So I'm apologizing that my message has not reached members, that there is the problem of transport, and I emphasize the transport because Parliament has availed buses for members to move from parliamentary villages to Parliament. And all of us who have been called back to Parliament, except those that have got a difficult conditions. So I responded to Parliament's call to come back to work. And Parliament has to provide transport for me to move from my village to the house, to the Parliament. And that's why I'm saying I'm going to inquire why the buses have been changed. The time of the buses have been changed. Not the rules, honorable members. And I'm still saying I'm apologizing. And I'm not saying I'm going to I don't know the rules. I've never said that, honorable member. Thank you very much.
Okay, can
Chair,
I come
it's Ngwezi.
Yes, honorable Ngwezi.
Honorable Chair, there is something very important that Honorable Mashala is raising. In the event where the chairperson is not there, or firstly, let me not come to what was supposed to happen when we arrive in the meeting. After having known, Chair, that your meeting, or you will not be arriving in the time that the notice has actually been provided for members, you should have ensured that members have got the new notice, which you had now actually negotiated with our secretary. We won't go to why the secretary did not send information to us. We are talking to you that your office should have ensured that there was now a new notice, because the meeting now that we went to at 9:30. Was no longer, it was a meeting now which had a wrong time. It was a second notice now. And that is an issue. That's why we're inquiring whether is the meeting still sitting in line with the rules. And secondly, Chair, members of the portfolio committee must not be held at ransom by the fact that the chair is not there, because rules cater for situation where the chair has a problem. Therefore, I'm appealing in the future, Honorable Chair, that I heard that Mr. Mashego, Honorable Mashego is a whip of the committee. The secretary was there, members were there, the delegation was there. And then we should have proceeded. I can't blame you, Chair, for that. I don't even want to say it's negligence by the majority members of the portfolio committee, because they should have appointed the acting chairperson. We did not want power to proceed with the meeting. Then when you arrive, you take over without any of the squabbles that were seen to be created by opposition and all that. Because what happened today was actually, disrespectful to us as members, not to the opposition, to all of us in the portfolio committee. Rules are there, they are neglected. The chair is issuing a new notice without, actually telling us that now, because of this, we will be moving to this. So this thing must never happen, Honorable Chair. We have no intentions of actually causing problems, in the portfolio committee. But when things like this, if they happen next time, you must expect anarchy. I'm not threatening. You must expect anarchy because you are the one who are leading as the ANC. But if you create problems yourselves, what do you want us to do? We will capitalize on the problems that you are creating. And as we discuss, we are giving you a warning. Even this corruption we're talking about, that is reported by the SIU, opposition parties told you long time ago, and you took time to act because they are opposition. Even today, these things we are raising, if you think we are raising them because it's our function or it's our duty as opposition to actually oppose anything you raise, I think you will be missing the point. Thank you, Chair.
Thank you very much, honorable members. Honorable members, I've heard you, but
And for that,
I'm saying, I've requested that I've apologized, honorable members.
Chairperson, can you allow us to speak? Our hands are up.
Oh, sorry, I didn't see the.
Me too.
Because I need to.
Can I be noted, Chair, at the end too?
Yes, we are not supposed to be here, Honorable Masobo.
But the discussion also affects us, Chair. That's why you kept me here, Chair.
Okay.
You're not supposed to be here.
No, but comrades, it affects me because if your conduct affects us.
Water. Please deal with that.
Honorable Masobo, please, can I allow members and then I'll give you your view, Honorable Masobo.
And you have
Honorable Musala, you have spoken, and let me give Honorable Mbana.
No, I wanted to concur with you on something, Chairperson. I wanted to say that you are correct when we said we should have elected an acting chairperson. Actually, we did that. But the secretary of the committee was the one who did not want to. She kept saying that you said the meeting must not happen. The secretary
Honorable
and Mashego was not
Honorable
of the committee, is the whip of the study group of the ANC. Thank you.
Honorable Masala, please, we don't have time. Let me give those that have not spoken. Honorable Bana and Honorable Mashiro will follow.
Thank you, Chairperson. I hear all the discussion, Chairperson, but in fact, I want to appeal to honorable members not to prolong the discussion and debate, because what you are saying is clear, we understand it, and you have apologized. And what the other honorable members are saying, it's also clear we all know the rules. The only thing maybe is this thing of not, whilst you were on your way, elect the chairperson acting. So let us not prolong it. Let's take it as it is, that you have apologized for that. And we should also blame all of us not to choose the acting chairperson. Yes, the secretary was reluctant really to do that. We always do that because you are not the cause of the delay of the bus, but really they were panicking. Everybody was panicking for waiting for 30 minutes. And when you request, or can you ask information about this bus, the chair of chairs must know that times of the meeting won't be 9 o'clock again. It will be moved to 50 or 10 o'clock rather than to do this chaotic thing. Otherwise, we accept all the apologies and we have noted all the concern from honorable members. Thank you. We also apologize from our side as members of the committee. Thanks, Chair.
Thank you, Honorable Mvana. Honorable Mashego.
Is my audible? Yeah, thank you.
Yes.
So, Chair, let me just say this thing. From my side, the chairperson spoke to me at 9:22 and said that I will be late. I have asked the secretary that we shall start the meeting at 9:30 because I was already complaining that nobody is accepting me to the meeting. And at the time when I came into the meeting, fortunately, Memshala and Babungwezi was already in the meeting. And we spoke our own things with Mashawa outside the meeting. 9:10, Mushala raised the point of us appointing a chair on the basis of the time that is going on Gwezi, in a way try to support him. I then raised the point that, no, comrades, in my view, Mamu chairperson who has told me that she has asked the secretary that we start the meeting at 9:30. It will be unfair for me to ignore that request and just go for appointment of the chair. And of course, the two leaders who did not accept Mushala and Babungwezi. And then I said to Vyogas, didn't the chairperson tell you that the meeting shall start at 9:30? She said she did. But then Vyogas said, but we can appoint the chairperson. I said, but it is going to be unfair because then we are punishing the chairperson for delay of a meeting that, because if the chairperson who has called the meeting says the meeting is 9:30, you can't stick to a time of 9 o'clock to start. But of course, there was a technicality of whether there was a notice written to us or not. But to me, when the chair says the meeting starts at 9:30, I thought it changes from 9 to 9:30. Therefore, your 20 minutes can start counting from 30:30 to 22 or to 10 to. So it was not about us not knowing that we must appoint the chair. It was on the basis, in my view, even now where I am, the meeting was postponed from 9 to 9:30. And Vyogas confirmed that she was told by the chairperson that particular point. Now, if we say, even if she said she was told, maybe she did not inform the meeting, the blame still stands that there is a rule of 9 o'clock. To me, I don't get the sense to that point. But for purposes of progress, I will not mind to say that that's fine. I take the point that, but the secretaries must appoint the chairperson. The secretaries must call for appointment, not us calling for appointment amongst ourselves. The secretaries did not call for appointment. So we could not have appointed because she knew that chairperson told her the meeting starts at 9:30. So and to me, to be honest, I take the point that you don't want to play politics on this matter, but you are, because I did inform yourselves at 9:10 that the chair has requested that we start at 9:30, but you refused to accept and say there is rules. Rules, but even it is a rule even to change the time.
Point of correction, it was 18 past 9, not 10 past 9.
We started at 10 past 9 minutes now.
It was 18 past 9.
No, the problem with you don't want to listen to others, but you want to be listened. You said others, no, it's not chapters, a minute, chair. No. Mutala likes to interject others.
No,
and when chairperson, no, don't do that because I will interject you, Nami, if you permit Mutala to do this thing.
No,
Mutala interjects it in yourself.
No, I'm not saying I'm saying I'm just reminding members of time that it's now already take 15 minutes to 2. The bells will be ringing. Members, we must go into parliament because we are here. I'm not going to connect. So can we summarize and so that we close the meeting, honorable member? I'm just requesting that, not that I'm saying Mhlala must interject the meeting. Proceed, Honorable Mashiro, and so that we finalize.
And honestly speaking, we must be respected like members of this committee. And if Mhlala believes she must interject everyone, she cannot be. It is wrong. We respect her when she is interjected. We also don't like it, but we don't like it either when she interjects others. I mean, let's respect one another. We are members of parliament. We are elected by people as equals. But when somebody speaks, respect that person. If you disagree, raise your hand and disagree. Don't interject. And when you interject, even when you want to put your photo on the screen for people to see that you are a champion of Aulas, it's wrong.
Chairperson,
Honorable Mokhotu,
on order.
Honorable Mokhotu,
please call that Mashiro on order. Chairperson.
Honorable Mokhotu.
You think you can address
you must remember that you're going to a man here.
Honorable
I'm not that way.
You are getting very personal.
The members of parliament.
Honorable members, can we listen to Honorable Mokhotu, please? Honorable Mokhotu.
That Mashiro is very personal and you don't call Mashiro out of order. I was just saying.
I'm not that Mashiro. I'm giving Mashiro.
You must just call that Mashiro.
I'm not that Mashiro.
Honorable Mokhotu.
Thinks he can threaten women.
I'm not that Mashiro, Mutala.
You must leave other issues not saying anything.
I am not that Mashiro.
Remain yourself.
I am not that Mashiro.
You are threatening women.
I am not that Mashiro.
Can you remove them?
I remove us all.
I am not that Mashiro. I better remove that. I will not allow you to believe you are God.
Honorable Mashiro, please.
Remove Mashiro. She's personal. Remove him. I'm quiet. Remove that one. Personal.
That one, who is that one?
Mashiro, you are
who is that one?
And can we allow the Honorable
Mashiro must be removed, Chairperson.
Rebecca must be removed. Rebecca must be removed.
Must be removed. It's getting very.
Rebecca must be removed.
When we are
Rebecca must be removed.
You are
Chairperson, can we adjourn this meeting?
Yes,
Can we
Honorable
close the meeting,
Mutala
please?
and Mashiro, you are disrupting Honorable Mokhotu. Honorable Mokhotu.
Yeah.
Honorable Mokhotu.
She's not there, Chair. Let's close the meeting.
Okay, thank you very much, honorable members. I want to apologize for any inconvenience that we have caused on you. You don't have to be angry and fight amongst yourself. I apologize for any inconvenience that we have caused. And this is the matter that I will engage with those that have changed the times of the buses so that we can be accommodated, all of us as members of parliament. Thank you very much, honorable members. The meeting is adjourned.
Thank you. Thank you.
Viva, Chairperson, viva.
Thank you.
Viva, Chair. Viva, Chair.
Kila kaleo kaspedi. Kila kaleo.
Bye.
Kaspedi.
Bye.
Bye, sis.
Bye. Bye.
Bye.
Bana. Bye.
Kila kaspedi leo. Mkhotore.
Bana.
Chairperson.
Meeting.
Bye.